Hi, everyone. Thanks for joining our webinar today. Today, we're going to be talking about developing healthy attorney-client relationships between public defenders or court-appointed lawyers and clients. I am joined by my very special guest today, Kenneth Hardin. I actually first, quote-unquote, met Kenneth when he spoke at the Virginia Indigent Defense Commission, CLE, back in the beginning of May, and his presentation was just so great. I reached out to him and he was nice enough to do a presentation for all of us today. So Kenneth is an assistant public defender with the Harris County Public Defender's Office in Houston, Texas. Kenneth is also a member of the training committee at the Public Defender's Office and frequently gives presentations both inside and outside of his office. Before joining the Public Defender's Office a year ago, Kenneth was a supervising attorney at the Orleans, I know I shouldn't say it that way, Orleans Public Defender's Office in New Orleans, Louisiana, where he practiced during the last 8.5 years. He was born and raised in Louisiana and received his undergraduate degree from Louisiana State University before graduating law school from Thurgood Marshall School of Law. Kenneth has handled and tried several hundred cases over the past 9 years, including but not limited to drug, burglary, robbery, murder, and rape cases. Over the last 6 years, Kenneth has shifted his focus on increasing community awareness regarding the negative implications of mass incarceration and was featured on BET's The DA versus Black America, as well as was on 60 Minutes with Anderson Cooper discussing the impact of underfunded public defenders' offices, which we all know too well. Kenneth also co-hosted a full-day seminar for the NFL and New Orleans Saints on oppression in the criminal justice system and the challenges that public defenders have in changing the narrative. In addition to being licensed in Texas, Kenneth is also licensed to practice law in Louisiana and the Eastern District of Louisiana. Kenneth is recurring faculty for the Harvard Trial Advocacy Program, the Alan Ray Bolin Trial Advocacy Workshop, and Gideon's Promise. Outside of his faculty roles, Kenneth is a board member for Gideon's Promise, a graduate of the National Criminal Defense College, a graduate of the Louisiana Defender Training Institute, and a member of Kappa Alpha Psi. In August of last year, Kenneth was the recipient of the 2019 Stephen B. Bright Public Defender Award, a national award given annually in recognition of attorneys on their contribution to improving the quality of indigent defense. That is a mouthful. Kenneth obviously has a very impressive resume, so I'm very much looking forward to this presentation today. Kenneth, I'm going to turn it over to you, and then anybody that has questions, just pop them into the chat box and we will get to them at the end of Kenneth's presentation, or I'll be monitoring it. So if I think it's particularly relevant, I'll bring it up when you're presenting. But Kenneth, I'm going to hand it over to you.
Thank you. Thank you very much. I really am honored to be here and to speak with the attorneys of Prince William County in Virginia. I know that the job that we do is it's an honorable one. And it's a job that I don't take lightly. But before I begin, I would be remiss if I do not say that I hope that you are all being safe. And I hope that everyone is okay, not just professionally, but also mentally and emotionally during these unprecedented times. I know that we're going through difficult times. So with that being said, if my presentation can help or improve in that kind of way professionally, but also just take your mind off of things that are going on outside in the world today and beyond, then hopefully I can do my part in doing that. I am honored to be here. I have given this presentation to the Virginia State Bar Association, where some of you I may have seen, or some of you may have seen me there. I am honored to do this again on the subject of what I think is the most important subject, client relations. Client relations. It's important because it's the essence of everything we do. So, in the spirit of talking about client relations, let's be clear what we're not talking about. We're not talking about parent-child relationships. Obviously, those are ongoing relationships, just like our clients' relationships, but nonetheless not that. So, are we talking about friend-to-friend? Friend-to-friend relationships obviously are another thing that, depending on the level of your friendships and how long you've known them, may be ongoing, may be temporary, but nonetheless, that's not what we're talking about. And we're certainly not talking about intimate relationships. There are courses designed for that, but this is not one of them. So in the spirit of relations, we're talking about specifically client-centered relationships. And I use that term client-centered because I know that many of you have heard this term before. But I want to be specific because our job, especially as public defenders, court-appointed attorneys, our job is a little bit more challenging in the sense that we don't choose our attorneys. And I mean, we don't choose our clients, not clients do not choose us. We inherit the fact pattern, we inherit everything that comes with it, and there's a certain beauty to it because our job is trifold, is the way I like to think of it. And one thing I like to think of it when I refer to client-centered, and this is borrowed from Gideon's Promise. Gideon's Promise is an organization I'm proud to be faculty member of and a board of director member of. And this was a lot of these concepts may seem familiar to you because Jonathan Rapping, the president, the founder of Gideon's Promise, is the person that created the training manual. So for those of you that have that training manual or purchased that training manual, a lot of these concepts and everything I'm going to be talking to, a lot of what I'm going to be talking about is reference to that. So when I speak with client-centered, our job is more or less threefold, right? We have the warrior, I like to think of, the person that goes into court, basically takes names, like kick ass and take names kind of person, right? Where you're litigating everything, you're ready to take things to trial. Y'all know that person because you probably have been that person, maybe still are that person, right? And then you have the activist, the person that everything is tied to the systemic issue, right? Whether it's bail reform, whether it's the movement that we're seeing from our heroes today in Black Lives Matter, whether it's a lack of accountability by the DAs or police reform. We have that particular piece. And then we may have the social worker piece where our clients have needs that we want to make sure that they're tended to. Maybe it's access to the medication, or maybe it's mitigation. Maybe it's collateral consequences they've experienced after, right, a resolution of a case, right? So my point is that we have this triangle where we're being the activist piece, where we're being the fighter, and then we have this activist piece where it's constant rotation. And that's what makes our job challenging, but also rewarding. So when we talk about this concept of client-centered representation, that is what we mean. So when we're talking about everything centered on that, what we want to be focused on is how do we empower our client and how do we use and how do we develop a relationship that empowers our client and keeps our clients on the same team. So on that note, when you hear the word client relationship, the word interview may come to mind. I really do not, you will not hear me use the word interview very often because we know you know how to interview. We're not talking about client interviews. Your face will probably look like this, right? And by the way, for those of you that are watching this presentation, one of the things that I am known for notoriously is that I'm very unpredictable, and there may be pictures that pop up that you may identify with, some that you do not. So at the very least, about leaving you in anticipation as to what comes up next, and I'm doing my job. So for those of you that are vacuuming, that are moving around, multitasking, and you're coming back and forth to the screen, and then at the very least, you're going to be, oh my God, what is he going to show next? Okay, so at the very least, tune in for that purpose. So this might be your face if you're hearing about client interview, but as I said before, we're not talking about interviewing, and I want to be specific here. When I think of the word interview, I think of a short-term, one thing, right? You are interviewing, you're talking to your client, and it's a one-time thing. But a client relationship is ongoing, it is sustainable, and that is one thing that we want to distinguish. We're talking about developing client relations. So when we're talking about the objectives for this presentation, you want to identify some of the hurdles that may impact having a healthy client relationship, but you also want to talk about how we are going to overcome some of these hurdles in order to sustain it. So those are going to be our goals, and we're going to center everything we're going to talk about today, particularly on that. So let's begin with the very obvious. Do clients trust us? Now, I know that I can't engage with you right now, so it's a little bit weird asking myself this question, so I'm going to ask you to digest on that. Do clients trust us? And your answer to that may be varying, right? Your answer may be say, hey, some of you may say, hey, all my clients trust me because I'm client-centered and I'm the one that's doing everything I'm supposed to do, and that may be great. But sometimes, no matter how client-centered you are, that trust is still hard to attain. So let me go ahead and stay out on the limb that maybe our clients, some of our clients don't trust us. And what are some of the reasons for that? What are some of the reasons for that? That is what we're going to get into. So when we talk about why clients may not trust us, that gets us into this next topic, stereotypes. And I want to focus on these stereotypes because this is going to be the essence of this entire presentation that we're going to discuss. These are the hurdles that we are identifying. So Normally I would ask this question to all of you to name some stereotypes, but I'm just going to go ahead and suggest some stereotypes. I'm sure that some of you may have a lot more than this, but for the purposes of this, I'm just going to identify about 5 or 6. One of those may be that they believe that we're aligned with the court and the state, right? How many of you have heard that before? That we work for the state, that all of us are paid together, right? We all dip out of the same pot and we have this predetermined solution for the case that everybody knows about except the client. Another stereotype is that we're incompetent. We don't know what we're doing, right? Obviously, we're just shuffling along and just hoping that we throw something on the dart and hope that it sticks. Many of you may have heard that. Some of them believe that we're public defenders because we couldn't get another job. This was the bottom of the barrel. We had nowhere else to go. So we had to rely to get on the court-appointed list. So we had to rely to get on the public defender's office. And that is not the reality. Now, whether it's ever been the reality, I can't speak to. That might be before my time. But look, back in my time in New Orleans, I was on the hiring committee. And I can tell you right now, it was pulling teeth to find the best candidate because our applications were a list and a mile long. Same situation in Houston. So I do not, that is certainly not a reality that I can attest to. Another is believe that we don't care, right? That they are part of a process line and that we are just trying to get our check. We just want that guaranteed income and really focus all of our attention on the paying clients or whatever the case may be. Just get them along so we can go back to what we're doing. Another perception could be that we think they're guilty, right? We think you're guilty already. And maybe we don't care whether you're guilty, but we certainly think that you're guilty. That is some of the perceptions that clients may have. Another that branches off of that is we won't fight for as hard as them. We won't fight as hard for them because we think they're guilty, right? You have to prove it to us so we can go prove it to other people. So these are some stereotypes that I'm sure that many of you can think of, think beyond this, but these are some that we struggle with probably on an everyday basis. You may see one, you may encounter 1 to 5 of these on every day that we go through because that's part of the challenge of our job. So when we talk about these stereotypes, we're going to dive into each of them, what they look like, and we're going to discuss hypotheticals that play out these scenarios and these stereotypes and how to overcome them. You know, and on the subject of public defender stereotypes, just kind of a fun note is the name game. Many of you may have heard many different remixes on the public defender name, and just to name a few, you may have heard us referred to as a plea lawyer, free lawyer, law clerk, public pretender, and public offender. I've been called all of these, some by judges, some by clients, some by family members and loved ones. So these names rotate through the anatomy of our careers as public defenders. But I want to go ahead and reach out and say, look, I'm a career public defender. And I have been practicing and actually I'm no longer a supervising attorney. I'm actually a staff attorney at the Harris County Public Defender's Office. So I am in the trenches the same way you are. So one thing I want to encourage you is not to let these names get you down. I know that you put your everything into it, but you have to also see things from perspective, right? We're meeting people at the worst time in their life. We're meeting people during the worst circumstances of their lives. So I believe that they're owed a little bit of latitude, a little bit of freedom to kind of be in their emotion and to be and exist within that traumatic state. So I ask you to, when you're called these things, you know, treat it like a water off a duck's back, like my dad would tell me. I know we don't do war stories, but I want to say just one thing about this name game. There was one trial that I did a few years back. It was a simple burglary, habited dwelling, and aggravated assault with a firearm. It was a 3 or 4 day trial. We were blessed in the fact that we got a not guilty. It was a hard-fought victory, but I'm not going into the litigation as to what got us there. The funny part is that after the fact, my client turns to me and says, you know what? I can't, you know, you did an awesome job. I can't wait till you take the bar and become a real lawyer one day. So I don't know how many of you have had that experience, but my point in all of that is a lot of times we associate these names whenever we do something bad, but sometimes you will get these names even when you do something good. So my point is even more of a reason, right, to understand perspective and not to let this determine how you're going to handle the case going forward. So on the subject of healthy client relationships, it's important like everything. If you're in the middle of a trial, when you're starting a trial, you want to start with opening statements from the bank. Everything is important to get it from the start because everything you do is either creating the stereotype, reinforcing the stereotype, or breaking it down, right? You're either creating it You're either reinforcing it or you're breaking it down. And we want to make sure that we're doing the latter, breaking it down. So my point is that, right? When we talk about, well, Kenneth, how do we get there? How do we get that help? Well, it's important to know that the quality information that you get, right, it determines the strength. So you may say, okay, fine, I get that. The quality determines the strength. But how do we get the quality of information? Earning that client's faith, earning that client's trust, because that correlates to the quality of information. Now, many of us meet clients at their, we meet them at their worst, and a lot of times we meet them, they're often in jail, and they're so eager to talk to us, right? And we think that eagerness suddenly means that they have all the faith in the world in us. Just because they're eager to speak with you does not necessarily mean that they have faith in you. That eagerness is based on a short-term, based on the need for that short-term solution. Get me out of here, or get this, or even if they're out of jail, get this thrown out, right? Get this dismissed. But a lot of times those solutions are not realistic, giving the reputation of your DA's office or giving the reputation of that judge or whatever the case may be, despite some of the things that may actually warrant that. But that being said, don't misplace that eagerness for trust. You have to earn that trust, right? You have to earn that trust. And there are some things that we can do to make sure that we're going towards the direction of earning that trust so we can get high quality information as our client and use them not only to empower them, but as an important investigative tool. So when we talk about healthy client relationships, there are verbal and there are nonverbal components. I already discussed before why I don't like the word interview. But more importantly, I don't like the word interviewing because it's mechanical, right? When you're interviewing, what's your name? How old are you? Are you born in the US? Are you born and raised in Prince William County? How long have you been here? What brought you here? Right? I mean, when we start getting, now I understand some of these things are important to creating ties to the community, which is a factor that no matter what state you're from, and I know in Virginia that's going to determine bond, right? That determines that determines whether they're flight risk. That is important, but how you get the information is even more important. So you don't want to sound mechanical. You want to know why? Because when your client, think about when your client has been through. Whenever your client is arrested, they're going through a checklist with the officer, right? Do you have your identification? It says your date of birth is here. What is your name? What is your address? What is your most recent address? They're getting the same thing. And then they exchange their wardrobe for an orange jumpsuit and chains. And then they're brought before a magistrate court judge or a PC court judge, right? And they're asked the same things when they're determining whether they're indigent and qualify for you, right? The same checklist. And then here you come, my name is the public defender and you're saying I'm fighting for you, but you sound just like them, right? And it's nothing more than a processing line. So in that client's mind, you are nothing more than a process. While they're eager to talk to you because you so say that you're the defense attorney, you're still part of a process psychologically because you're doing the same thing. So we need to distinguish ourselves. We need to distinguish ourselves by remembering the human component of client interactions. So how do we do that? Consider your introduction. Maybe instead of saying, my name is Kenneth Hardin or whatever the case may be, you walk in there and you look them in the eye and you say, how are you? How are you? Right? Let your tone, let your nonverbal language, let all that speak for itself, right? Let that communicate to that client just as powerful as the words. Now, some of you may say, well, he's in jail. How do you expect him to be? Point noted. There are qualifiers. Look, I understand that given where you are, things are not great. So how are you holding up? Right? Meet the client where they are and listen to what they're saying. Understand that you care about them as a human being, right? And transfer that by deeply asking these questions, by diving in deeply into their lives, right? We want to get to know our clients and we want our clients to get to know us because that's the only way faith can be exchanged. You do it every day in your relationships. You do it every day with your significant others. You do it every day with your friends. You do it every day when you're building trust. So why are our clients any different? Checklists. We talked about avoiding checklists and how mechanical they can be. Scripts. My name is Kenneth Hardin. I'm an assistant public defender at the Harris County Public Defender's Office. You have been charged with second-degree kidnapping. Let me go over the elements to you with second-degree kidnapping, right? That's all great. That's all great. But you also, it's very mechanical and you want to make sure, while these are important information, you want it to be a discussion, an ongoing discussion with your client. Now, I know that some of you may be on a time limit when you're talking with your clients, and we'll discuss how to handle that or suggestions how to handle that a little bit later. But assuming that you have a little bit more time on your initial client meeting, You want to make sure that you're not sounding scripted, right? You want to be to avoid that. Word choice. While this may sound great, you know what? I looked over your case and I believe there may be some suggestivity to the photo array. So therefore, we may have sufficient grounds for a motion to suppress identification. And based upon a client interview, there was no opportunity to observe. There was no degree of attention. These are all factors that go as far as whether their identity is reliable. That all sounds great. But look at your word choice, right? Even to another lawyer, that is, to me, very dry. Right? I may understand what you're saying, but I certainly have lost interest. I've lost a connection. So when you talk with someone, be yourself, but talk to them how you would talk in a natural environment. Whenever you go to, well, pre-pandemic, whenever you go to a bar or wherever you go to the pool and maybe the conversation of law comes up, just like how we over-addicted attorneys do, I truly doubt that you talk that way, even to each other, but even more so to a layperson. So you want to keep that in mind when you're talking to your clients. Now, I'm not trying to suggest that your clients are slow or they don't have intellect to understand that, but you certainly want to create a dynamic where you are yourself and you're not trying to sound like, oh, I'm this educated lawyer where you're looking down on them, right? So you want to consider it from that perspective. And another thing is natural conversation. Let things come up naturally. So all these topics, the elements of the charge, let them come up, right? Don't get this caught in your script like, oh, I'm not there yet. Let me stop you. Right? You want to be sure that you let these things come up naturally because they're going to come up. They're going to come up. And one piece about the natural conversation is that if your client tells you, my mom is sick, she suffered from stage 2 cancer, that's not a good time to say, well, I'm sorry. Well, let's talk about this aggravated robbery case right now and what they're saying is the evidence against you. That's not a good time to do that. I understand that she may have had a goal to get through a certain amount of to get through a certain amount of covering materials. But this is a time to let that client, I know that you can't make that go away, that stage 2 cancer. You can't make it go away, but what you can do is allow that client to exist in that space. Allow that client to exist in that space and you exist in that space with them, even if it's simple as in, I'm sorry. I know that can be hard for you. If you have a personal story, look, my mom suffered from cancer. I know how painful that can be, and I'm gonna do everything I can to be there with you as you go through this, right? Something as simple as that, right, can help and go a long way. And remember it, memorialize that. When you come back, even if it, God forbid, if it's a month later, you know, how's your mom, right? You've already started a connecting piece to show that client that you value them as a human being. So you want to consider that when you're doing that. All those things help towards building faith and building quality of information. You don't want to look like this, right? And this is a good movie for those of you that haven't seen it. It's called Office Space. And I am getting to the point by explaining it, but these two gentlemen, for those of you that haven't seen it, this gentleman, Peter, is a guy that kind of goes through the mechanics. He goes to the office every day. He's a great employee, but he just kind of gets tired of going through mechanics, kind of like the quarantine, kind of like Groundhog's Day. We get up and do the same thing over and over and over. This guy is doing it without quarantine, right? But this is his same thing, and he's tired of it. He wants more in life. And these two guys have been hired to come in and look at the office, right, and examine what parts of the office are working efficiently and what isn't, right? And they meet Peter, who by this time have given up on all the office politics and bureaucracy, and you see how he's dressed, right? So I say that because nonverbal communication is big, it's huge. And that is the other piece to building quality and faith, right? You look at Peter over here and he just doesn't care. And you look at these two guys, they're all invested in. So you want to make sure that see, body language communicates a lot. It communicates a lot. It's more powerful than verbal. So whenever we talk about body language, and we talked about those stereotypes, right, that we discussed, what body language are you communicating? And this is why normally I never give a presentation sitting down, but I want to demonstrate this. What is this demonstrating when you meet a client? Or this. My favorite one is this. What are those stereotypes? What are those stereotypes? Now, we do it naturally. Look, I'm guilty of it too. We do it naturally. But think about it. The phone holding up shows that you obviously don't care because you're focused on something else. You don't have the undivided attention, and you're probably only there for 10 minutes anyway. Does it really hurt to pull down the phone? You know, and This probably shows like, okay, going on, I believe that, you know, you think they're guilty, right? And that might not be true, but your nonverbal language is showing that, right? And this just shows like you're just really going through the motions, right? That my point is that you're meaning that like I'm aligned with the state, I kind of already know, you know, just get on your line anyway, right? So you don't want to, you want to make sure that you're conscious of your body movements. That is just as important as what you say. You could be saying all the right things, but your body isn't, right? And your client may not tell you, but they've already cut off that trust. And once they cut off that trust, it's hard to get it back. So you want to be very conscious of verbally and non-verbally what you're doing. So here's the good news. Some of you may say, oh, that's a lot to think about. I got 250 cases. You know, hey, I can't be doing that for every client. You know, or better yet, you know what? I am doing all of this. My client still hates me. Well, here's the good news. Perceptions can change. They can change. And they often do. Because people may not remember what you tell them, but they do remember how you make them feel. Some clients, it won't happen in a meeting. It may happen over the course of a case, right? You may have to work a little bit harder because you don't know what they've been subject to. You don't know what their experience has been. They haven't told you yet because they don't trust you. So the point is that you don't know what they've been through to make them the person they are today. And don't assume that it's a crime. It may be abuse. It may be neglect. You don't know. So you want to consider that, but perceptions can change. You can turn from this, Steve Rogers, right, into, and you all know it's coming, Captain America. I am a Marvel geek. I will not make any apologies for it. And I love the movies, and I love what they stand for. So, hey, let's just go ahead and move past that. So yes, perceptions can change, and they will change if you work for it. So what are some ways we can make those perceptions change? Well, now we're getting to the piece of overcoming some of these hurdles. One of the ways we can overcome these hurdles is doing what your degree has taught you to do. Know your trade. Educate your client. What does this mean? Knowing what they're charged with and knowing the elements, right? Being able to answer some of the questions and anticipate some of the questions, right? Knowing the penalties, knowing the defenses, knowing the legal concepts, right? I'm not saying that you have to walk in there with a working defense theory. I'm saying that at the very least, you could talk about, hey, you know, what they claim is that you made a statement. I don't like to call the word confession because confession means that they think you did it. So let's just call it a statement. And a statement is this. And then you start talking about, you know, why is this powerful? Why can this be good or why this can be bad? You may start giving them little hints and previews as to what it is, right? And maybe even use words like that, right? If they just talk to you about how much they love movies and start using that language about movies, well, here's a preview of a way that I think that we can attack this. Right? Those kinds of things. So you want to make sure and you equip and empower your client. This is how you empower them. Now, documents and reports, I realize that there are some statutes that say there are different states that are different. Like in New Orleans, we can actually give our clients, we didn't like to give our clients discovery because we was afraid of jailhouse snitches and things like that. Usually I would suggest reading the report, but there are some like in Texas where we can't give them discovery. I know it sounds weird. I believe the discovery is their file and is theirs to keep, but we can't give it to them because they don't redact things. And because of that redaction and protection of the so-called victims, which I like to use the word complaining witness, we can't. So there may be other ways to work around that I can answer in questions, but just kind of make you aware. But my point is that you're empowering your clients by giving them information and knowing this trade before the visit, not during the visit, before the visit. This wouldn't be a effective presentation without referring to ethics. And so one of the things that as you are empowering your client that you need to be aware of, we often use attorney-client privilege and confidentiality interchangeably. And while they are in the same family, they are different cousins, right? So you want to make sure and understand some of those differences because there are some ways you can be caught within that web. First, with attorney-client privilege. Attorney-client privilege is probably one of the most usable things that you've heard even before you became an attorney. Obviously, this was coming out of the client's mouth, but they give you permission to, in the short end of the stick, right? What they tell you, what they authorize to say, what comes out of the client's mouth. But a lot of us forget about confidentiality. A lot of us forget about confidentiality in your rules as governed by 1.6. Right? And it's much broader than attorney-client privilege. It's not necessarily what comes out of the client's mouth, it's everything surrounding that representation of that client. And you want to make sure that you are mindful of that. So maybe even if your client did not tell you where he was, right? Maybe the client is telling you all this other stuff, right? And the judge is demanding to know where your client is, right? That is still within the realm of confidentiality. Maybe it didn't come out of their mouth, right? So you're like, oh, it's not privileged, but it's still surrounding the representation and the course of representation. But either way, whether attorney-client privilege or confidentiality, you can only break the client's consent, right? And then also confidentiality is broader in the sense that it breaks down what you can and what you must reveal, right? Which you may or may not be able to, and which you absolutely have to. So in looking at that, and I encourage you to look at your statute and your rules of 1.6 to really break it down. Just to kind of go through a few of these, obviously what you can is to comply with the law, right? If you have a judge that is ordering you to tell you where your client is, I am demanding you, where is your client, right? Then at that point, they can hold you in contempt, right? And contempt is a law, it's a statute, right? Whether it's direct or indirect contempt. Right, and this point, this is direct because they're giving you a directive to do so right there in front of them. So that is a situation where you may be forced to break it. Of course, I wouldn't do so without making a record, but nonetheless, in defense of a claim by representation, of course, right, when you're dealing with bar complaints and a few of those things to protect in a death or incapacity, and this is an important one because there are a lot of people that are losing their lives to this pandemic, and there may be a lot of you that know someone who knows someone, or maybe even know them directly, right? There may be a situation where this may be, where consent may be broken. Necessary for law office management, right? We work as a law firm, right? So anybody that's working along with that case, your investigator, your social worker, anybody that's working with you, they're included. Necessary for bookkeeping. I don't know how Virginia, I'm not sure how Prince William County does it, but defender data is something we use. So with that being said, is if you have a management system and keeping track of your files, right? Some of you as public defense, some of you as court-appointed attorneys, I understand there may be an independent contractor relationship, but nonetheless, if there is a reporter that you report to that governs your cases, that confidentiality extends to them. It extends to them, right? Because they are part of that case. They are part of that, right? Your employment doesn't have control over that. It's that client that dictates that, right? Where they're where they're working as an office because you have to report to them, right? Within the capacity of your job. So consider that with may. Shall reveal, obviously if they're going to commit something, right? Now, in particular, Virginia is important because advisement is key. After you advise, intention to commit a crime or intention to commit fraud, after you advise. Misconduct. Now, misconduct can be a little bit confusing because, if there's misconduct of an attorney, you can disclose the conduct of, you have to disclose the misconduct, but as it relates to the client, because you see misconduct with client consent, as it relates to the client representation and the matters, you have to get the client's consent, but the misconduct, that there is a misconduct, right, that's different. So you want to make sure you understand these rules and have a good understanding of how they apply on confidentiality. Now, do ethical rules ever clash? This is law. They always clash. Yes, they do. Yes, they do. They always clash, right? And so I want to just give a brief hypo of how they may clash, right? As we start to get into hypo mode. Ethical rules, and I'll just read them. You've just been appointed to a new client. Excuse me, let me put this up a little bit. You've just been appointed to a new client who is charged with distribution of cocaine. As you prepare to handle the initial hearing, which will include a bond hearing determination, you meet with your client. You ask client if he or she has been convicted of a crime before, and the client replies that he or she has 2 convictions for distribution of cocaine. When you receive the bail report that is given to the judge, she knows that it's silent about criminal history. The judge turns to you and asks, do you have information about your client's prior history? Now, the key to note in this case is that, you receive the bail report that is given to the judge. She knows that it's silent about the history, right? So in other words, you have the information. So just kind of in multiple choice format, let's discuss, what does it look like? How do we approach this? Yes, I do, Your Honor. While I have not verified this, it is my understanding that he has 2 prior convictions for distribution of cocaine. Your Honor, this is my client's first time ever being arrested. I don't have to tell you anything. If you want to go find out yourself. I do not have the information that I'm able to provide the court to supplement the bail report. There is no criminal history reflected in the bail report, and I would ask the court to rely on that for purposes of this hearing. Now, some of you may look at these answers and honestly be twisted, right, as to what to turn. Some of them you may actually want to say. So let's discuss them. A, obviously, you're interested in pleasing the judge, right? It's not client-centered, right? It's not client-centered whatsoever. but more importantly, it violates 1.6. It doesn't violate 3.3 candor to the court, right? It doesn't violate 3.3 candor, but it does violate 1.6 because it's related to the confidentiality, right? And then you have first time being arrested. That doesn't violate 1.6, but it certainly violates candor to the court, right? That this is the first time ever being arrested, because should they find out and connect that back to you, then that is a direct lie, right? So you want to be careful about those things. Now, this one, I don't have to tell you anything you want to go find out. That is the answer that most of us may feel most emotionally connected to. However, and it does not violate 3.3 or 1.6, but what is the goal? Consider the goal. The goal is it's a bail hearing, right? So do you think that you're going to accomplish the client's goal by doing that? Probably not. Even if it is a close friend of yours that's on the bench, you probably won't. They're going to feel some kind of way about that. I would feel some kind of way about that. And let's look at D. Ding, 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 right? But notice the italicized language that I am not able to provide to the court, right? That I'm not able to provide to the court. That is where you're not saying that you don't know. You're saying that you're not able. Why you're not able? You can fall back on the rules. One thing that judges do, who are intimidated by, a lot of them at least, is holding them accountable to laws, right? Holding them accountable to ethics. So, if they're pushing you and they're pushing you, surely, Your Honor, surely you're not asking me to violate 1.6 confidentiality. It is my impression that this falls within confidentiality, right? Then that judge is going to have to stop back and think. They're going to have to step back and think about that, right? And if they're pushing you and it gets to a situation where you get into that may reveal in 1.6, then maybe you ask for a court reporter. Like in New Orleans, we had a court reporter always there putting everything on the record. In Houston, we actually have to request a court reporter to be present. So I'm not sure where your jurisdiction falls, but if you're being demanded to say things, then ask for a court reporter and put it on the record, and that is your belief that you're being asked to reveal information that's subject to 1.6 confidentiality, right? Or attorney-client privilege if that applies as well. So there are things that you can do within litigation that can either protect you to say, understand not to do that again, or B, at the very least, protects you ethically. But when in doubt, use the magic words, I cannot make any representations, right? It's the safest phrase in the world, safest phrase in the world. You're not saying that you don't know. You're not saying that absolute to anything. You can't make any representations as to that. Or if you really want to sound fancy and you want to protect yourself from the rules, I'm sorry, Judge, 1.6 confidentiality prohibits me from making any representations to that, right? So those are your magic words. So back to your public defender stereotypes, right? And remember the ones that we talked about. Align with the court and state, couldn't get another job, don't care, think we're not guilty, won't fight for them as far as we think they're guilty. Let's look at some hypos that go strictly towards those stereotypes and how to overcome them. Lawyer sits down to meet with client charged with assault with a bottle. The client has been adamant that the victim identified the wrong guy and that he was not there. The lawyer has fingerprint from the lab that says that client's fingerprint was found on the bottle collected at the scene. The client says the report is wrong. The lawyer says, look, you obviously want to be in truth with me. This fingerprint evidence is never wrong. Now, this is in my belief, right? And again, these are hypotheticals that are referred to in the training manual within Gideon's Promise, but it's also realistic. These are things that happen every day. Maybe this conversation is not as realistic, but the existence of this scenario is. So how do we deal with that? Well, first, before how do we deal with that, what stereotype does it fit, right? And particularly the words, right? It definitely shows that you're aligned with the court and state, because whatever fingerprint evidence person they get, is probably going to be a witness for the state. So it shows that you're on their side. It believes that you think they're guilty, right? It probably fits more than one of these if we sit there and we add a reason for it. The point is that it definitely fits a stereotype, and you don't want to do that. So with that being said, how do we overcome it? Show that you're willing to presume that they're innocent, right? So maybe your conversation is, I don't know whether these results are right or wrong, but what I can tell you is I'm concerned about how a jury may see this. I'm concerned about how a jury, right? And explain to them your experience of how juries may assess it, right? But also talk to them about other ways, right? Other ways that you may look at this, right? Well, look, I am concerned about how a jury may see this, but there are some suggestions, there are some strategies I'd like to discuss with you. One of them is, I think that maybe we should try to see if we can get this report out. Maybe they turned over the report too late, right? Maybe discovery loss, right? Maybe you can consult with an expert. Maybe you don't have the money to get an expert, because not many public defender offices do. Maybe you could consult with an expert, right? And just talk with them about these results and how they would look so you can bring that back to your client, right? Maybe you could talk about, maybe there's some evidence blocking techniques. Maybe they don't have, maybe they won't be able to get the witness, or maybe something like that, right? Maybe how do you exclude the witness from testifying? Those kinds of things, other ways to block that. Maybe discussing other theories that don't involve that, right? That doesn't involve the results, such as consent and how that may look to a jury. Discussing options rather than just saying, you know what, we don't believe, I don't believe your report is never wrong. It's not the way to go about it. So separate yourself from the system. Separate yourself from the system. Don't ask questions that assume guilt, kind of like that last attorney did in that hypo, right? You want to, and what I mean by that is you want to consider questions, right? For example, what will witness say versus how do you know? A lot of us will read a report, go back to that initial client interview, and a lot of us will say, it says here that the victim is Daniel Kim. How do you know Daniel Kim? Well, first of all, you just called him a victim, right? A victim is similar to is similar to the difference between arrest and conviction, right? Just because someone's been arrested, they've been convicted, or just because someone is calling themselves a victim, does that mean that? No, they're a complaining witness until there is a conviction. You don't become a victim until there's a conviction, right? And that is my take on it. I know some other lawyers and some other people may disagree, but victim is very conclusory. So you want to be very, very, very careful about the language that you use. And first of all, why are you assuming, and then how do you know Daniel Kim? First you call him a victim, how do you know Daniel Kim? Why are you assuming that they even know Daniel Kim? Maybe they feel from their perspective, they were just walking on the street and they just got stopped and they don't even know why they're there. So you want to make sure and be very careful. Don't assume anything. Maybe you may say, you know what? I'm going to read to you this report, which is their version. And by they, I mean the prosecution, the DA, the state, the Commonwealth, whoever you want to refer to them as, they're all the same thing to me. So they say that the complaining witness in this case is Daniel Kim. Does that name mean anything to you? Does that name ring any bell to you? Do you even know who this person is? And then from there, that's going to trigger, if they say yes, how do you know them, right? And then you're getting some investigative information, quality of information that we talked about, right? Quality directed to the strength of the relationship. You're getting these things now, and now your client is an effective investigative piece without judging, without judgment, and without that cloud of, making them feel like you're guilty. So you want to be very, very cautious about how you ask these questions. Consider how to relay information that doesn't suggest guilt, just like we were just discussing, as far as whenever you're going through the various parties that's connected to a particular report. Now, one thing I do want to speak on is Thurgood Marshall. Thurgood Marshall is a very, very influential figure in my life. One, because he is the first African-American Supreme Court justice, and he looks like me, right? At a time where people that look like me just did not succeed at that level despite their efforts. Below you is the law school, Thurgood Marshall School of Law, that I went to, that was named after him. I went to that law school. It's in Houston, Texas, not too far away from my office. I'm a proud graduate of this HBCU law school, named after this man. And it's important that, ironically, I say HBCU, yet this is a man that is responsible for what? The famous 1954 Supreme Court case, Brown versus Board of Education, right? That basically demonized segregation, right? And held that segregation was unconstitutional. There was a movie made about Thurgood Marshall, and I want to show you a clip from this movie. As you watch this about a minute clip, I want you to think about these stereotypes that we discussed. I want you to think about these stereotypes. And I want you to think about whether any of these stereotypes are visible or notable within that clip.
Kenneth, I can't hear the audio on my side.
You can't hear it?
No.
Okay, I will try to go ahead and explain a little bit of it since I've seen it. Can you see? You can see the visual? Okay. The clip. Now, if some of you have experienced what, if you couldn't hear it, I hope that you at least look up this clip, and I'll try to briefly explain what happens. Basically, the gentleman that you saw that was standing up plays Thurgood Marshall. By the way, I'm not suggesting that any of this conversation actually happened with Thurgood Marshall, but this is back when Thurgood Marshall was a lawyer, set in the 20s. The gentleman sitting down was accused of raping a white woman. And Mr. Thurgood Marshall was working with the NAACP, and that's when he walked into the jail, and you saw him look behind as the bars were closing. You noticed that. And you notice he stays standing up as his client is sitting down. And what he said is, he actually introduced himself. He said that he's Thurgood Marshall. He worked with NAACP. He explained what they looked for, and they identified colored people who were arrested that they believe could have been innocent. And he made sure and emphasized that we only represent innocent people. And did you rape that? Why did you rape that woman, Joseph? He needs to ask him a serious question. Why did you rape that woman, Joseph? Why did she say that you did? And he said, and then at one point he looks at me, he says, look at me now. Did you do what they said you did? And then the client looks up and says, I did not touch that woman. And then he says, Joseph, you got yourself lawyers now. They shake hands and he walks out. Now, that's the clip. And this is how they're portraying the Thurgood Marshall. And again, I'm not suggesting that there's no proof that this actually happened this way, and then no one's suggesting that it did. My impression is that's just for movie effect. But it's important because even from someone like him that's celebrated, right? He has the status. A lot of times public defenders, we're working from the ground up, dealing with these perceptions that we're talking about. He already had the status, at least amongst people of color. And yet he says some very identifiable things with the stereotype. He introduced himself with the NAACP, so he made it clear that he's not aligned with the court and state. But all these questions, did you rape that woman, Joseph? Why did they say you did? He goes into automatic asking these questions. I believe his intention was to use this client as an investigative source, but what he did was make this client think he was guilty. But more importantly, he made the client believe that he won't fight for him unless he's guilty. We only represent people who are innocent. He said that, right? And so these are all things that push this client into that position, right? And at this point, if I'm the client, regardless of what I'm telling him, I'm feeling like I have to prove my innocence to my attorney first, right? So what does this mean? Advocate, don't assess. Another way we overcome barriers, right? That's what that clip is meant to talk about. Know your role. Know your role, right? Your role is not to determine innocent versus guilt. That is the fact finder, right? That is the jury or that is the judge if it's a bench trial. Your goal is to reach a desired outcome. You are not there to display your personal feelings and personal emotions. And more importantly, you don't tell your client, you show them. You show them, right? And many times, I'm not saying that we ignore who we are and we ignore our convictions about it, but you want to be mindful of how you express it within a way of putting the client in a box to make them feel like they have to prove themselves to you, because you might find that what they tell you may not actually be accurate, right? A lot of people I've heard a lot of attorneys say they based on, I know when my client's telling the truth. I know when they're not. Well, first of all, who are you to put so much stock into the report? You met your client. More than likely, you haven't even met the police officer that wrote the report, but yet you are just, not to offend people who are atheists, but you're believing it like it's the Bible, right? And you're holding on to it like that. And who are you to be dismissive of it, right? But yet we are. Well, the report says this, report says that. You sound like the prosecutor approaching the judge about a bond. They're saying the same thing while they're justifying why they're asking this high-ass bond, right? So you want to be very careful about that whenever you talk with your client, right? Don't be judgmental and don't convey personal belief about damaging evidence, right? Of course it sounds bad that a woman was raped, according to that particular, just using that scene as an example. It sounds horrible, right? Of course, if a child was touched or anything, or any of this sounds bad, right? But remember, we represent the person, not the crime, right? Take in perspective, for example, whenever many of us have sat in the kitchen, and I'm not just talking about as lawyers, before your life as lawyers, you'll see somebody in an orange on a TV screen. And usually what you'll see is such and such was arrested today for, let's say, something gruesome as in, robbing a man at gunpoint, pistol whipping him and taking his money and then raping his girlfriend and all this other case. These facts do sound horrible. If you're a human being, they sound horrible, right? But think about that. As you're watching in your TV, more than likely, you or a loved one is saying, man, I hope they bury him under the jail. He needs to go, whatever. We've all said it. Even me, I've done it, right? But think about how many people that information has passed through before it got to your TV screen. First, you may have a witness, right, that calls 911, who tells a dispatcher, who gives a first reporting officer there. Then a first officing reporter gets to a detective. That detective goes to his supervisor. That supervisor goes to a news correspondent. That news correspondent goes to a reporter, and that reporter goes to you, right? 6 or 7 different people before it gets to you on your TV screen. And yet we formed a belief system based on 6 or 7 people. Look at what I'm wearing right now. If you go and you tell 6 or 7 people to get back to what I'm wearing, chances are you're going to get it inaccurate. And that's you, right? You trust your own self and you're going to get it inaccurate. So think about the inaccuracy of people who have no connection to each other that's reporting stuff down the line. And yet we form our belief system that they should do this and they should do that based off of that assessment. And then what are you seeing? A guy in orange flash as they're telling this hideous situation. You see a guy that's not smiling. And no matter what, the client is damned if you do, damned if you don't. If he does smile, then we're like, oh, he's insane. If he doesn't smile, then we're like, oh, look at this hardened criminal, right? What is he supposed to do? You don't know what's behind that smile. That frown. It could be, I'm worried about getting back to my pregnant wife while I'm here in custody. I'm scared because this guy just tried to beat me up in jail, or this police officer threatened me. Of course he's going to be frowning and look angry, right? So my point is advocate, don't assess, because all of these factors go into that. Now, scenario 3. Lawyer's in initial client meeting with client. Lawyer's initial meeting with client. Lawyer says to client, okay, the allegation is that you walked up to a woman on the street and began to beat her about the face without provocation. The woman says that she does not know you and has no idea why you did this. The lawyer then says, okay, now tell me what happened. The lawyer immediately acts by saying he was not there, whoever the woman is lying, and that he was not at home at the time that this happened. The famous, wonderful question, and this causes so many debates between attorneys, and even attorneys that I love and respect. Love and respect. The question, what happened? Does it fit a stereotype? Does it fit a stereotype? And I realize at the conclusion of this presentation, you may still feel like it doesn't. I take the position that it could fit a stereotype if you're not careful. I believe ultimately we need to get to what happened as we're forming our narrative, as we're forming our universe of facts to develop a defense theory. It's important. However, it may not be appropriate within the initial client meeting. You haven't built that trust yet. Think of whenever, for those of you that have a significant other, whenever you first met your significant other, you got to know them. And at the end of the night, you may have established whether you like them, but did you go, okay, now that I know you, I know that you're not crazy, let's get married? You probably didn't do that. Why? Because that's a bit forward, right? And we don't do that. We get to know things about them. We get to know areas of their life to make a determination whether this is a good fit for my life. Am I a good fit for your life? Now, I'm not saying you do that with a client. Are you a good fit for my life, client? No, I'm not saying that. What I'm saying is that you are having these universe of facts and you're gathering building blocks to create this narrative. And you are assessing information based upon that, what the government has to prove, what the state has to prove, and that's what you're focusing on, right? You have to earn that information and trust from your client as an investigative source. So when you ask what happens, it locks that client in to a set of events, a version of events, right? And this is why when asking what happened can go wrong, right? Forces client to commit without establishing a relationship. Now, I want to jump back to that clip that I just told you about with Thurgood Marshall. Now, remember I told you the last thing that he said was, I did not touch that woman? Well, spoiler alert. In this movie, this is what happens. It turns out that Joseph, the gentleman who's being represented, it turns out in the movie that he did have sex with this woman. And remember, this woman was she was verbally and mentally abused by her husband. It was a white woman married to a white man. She was verbally abused by her husband. She didn't get any attention. She was neglected by her husband, and she just wanted the desire to be touched. And Joseph was the housekeeper, the maintenance worker. And so she solicited him, and she had sex with him. She thought that she may be pregnant, and she freaked out. And in a moment of committed, remember, this is the 20s. And she was actually going to commit suicide after telling him that she feels she might be pregnant. Joseph follows her out. He follows her, jumps in her car, and they're having this argument by a river, and she rips off, I think rips off a piece of his clothing, and she jumps in the river. And then when she jumps in the river, that's whenever people find her, and she makes this story, right, that she was raped. So the point is that he didn't rape her, but he did touch her. Why didn't he tell Thurgood Marshall that? And in fact, he told Thurgood Marshall the very opposite. I did not touch that woman. That's what he said. So why would he tell the famous Thurgood Marshall of the NAACP, I did not touch that woman? Now some of you say he lied. Yes, it was something, he made an untruthful statement to his lawyer, right? To a lawyer that was fighting for him. Why would he do that? Well, gee, maybe, I don't know, maybe it was the forceful demeanor of a client, of an attorney glaring at you, asking you several questions. Did you rape that woman? Did you touch her, right? He felt that he needed to prove his innocence. And if he told his attorney that he had sex with her, right, maybe that attorney won't fight for me. So I got to tell him what he wants to hear. So you got to understand the matter of perspective, right? It forces clients to commit without establishing a relationship, which is very dangerous. Right? It incentivizes client, like this example we just talked about, to paint a picture of innocence. Client becomes wed to the version regardless of new information. I was a little bit of a trickster in how I arranged my hypotheticals. Remember the hypo when we talked about fingerprint evidence is never wrong, right? The hypo that we discussed. That's how you get into that situation, right? Your client becomes incentivized to paint this picture of innocence, and then all of a sudden, fingerprint evidence comes out, DNA evidence comes out, right? And then all of a sudden it's the exact opposite of what your client told you, and then you're feeling some kind of way that your client lied to you. Well, even if that's the case, did you create a zone of comfort for your client? Did you even create a relationship for them to feel like they can tell you everything and that you're going to fight for them no matter what? Look inside before you start throwing fingers outside, okay? So all of this can happen from this what happened question in an initial client meeting. So you want to consider that. Instead, you want to develop a client relationship that allows a client not to feel wed to anything that he tells you, to understand the focus is on what the government alleges, not the truthfulness of the allegations, what the state is going to show, right? You want the client to understand why it's important for him to help you determine what the evidence may be, right? What do you think this witness is going to say? They claim that these people are witnesses. What do you think in a situation like that? What would they say? And let's talk about how to attack it. First, let's look at it from their perspective, right? Get your client involved that way, right? And you may pick up some investigative nuggets about these people. Well, you know what? He had an armed robbery last year, and then boom, right? You didn't have access to that. Ding, ding, ding. Now you're getting into Brady, and now you're getting into other stuff to investigate, right? So you want to consider that, right? Maybe, and if nothing else, fall on the attorney-client privilege. Look, I can tell you, look, I want you to understand the attorney-client privilege. I know we've talked about it a lot, but I want to make sure you really understand the impact of how powerful that relationship is. You know, I want to let you know that you are free. I understand that you don't know me, and I understand that you may have been through trauma. I understand that, you know, memory fades over time. So my point is that you may tell me something today and feel the need that wasn't accurate or feel afraid to change it. You have that freedom to do whatever you need to do with me. And I don't necessarily have to know the why, right? I hope to earn the why, I really do. But I want you to know that's what attorney-client privilege is, right? You have that freedom, right? I'm not gonna, you know, so you wanna make sure your client understands he has that free zone, right? I'm not encouraging the client to lie, but I'm acknowledging the fact that there are things that happen, memory fades over time. They don't know me, right? But showing that I have a deeper concern about that attorney-client privilege and I'm gonna protect it no matter what, right? Of course, you know, can't, you know, not future harm or anything like that. Or you can't say, I'm going to lie on the stand and things like that. That's where you get into some other nuts and bolts that's not there. But you're having that conversation from onset to create this comfort zone. So you want to consider that in developing a healthy relationship from the start. Another thing from the start, the plea discussion. You know it's coming. No matter how strong or weak your case is, it's coming. So the best way to deal with it is to let your client know from the very beginning, right? Prepare a client for it. You know, maybe if you don't know how to start, ask them if they know what it is. Like, hey, do you know what a plea agreement is? Do you know what a plea bargain is? Well, let me tell you what it is, right? It's something that the state offers you, right? It may not be the charge you were arrested for. It may not be the reason why I came to see you. It may be something else, but they sometimes do this whether I ask for it or not. And I want you to know that if they do that, if they offer you a plea agreement, I have an obligation to tell you, by no means am I forcing you to take it. What we're going to do is we're going to talk about it, and we're going to make 3 decisions. We're either going to say, yes, we want it. We're either going to say, B, we don't want it and we want to go for trial. Or C, we'll take something, but not what you're offering. I like to think of myself as a trial attorney. I'm a fighter. But at the same time, I have an obligation to tell you. So if by the next court date, if they come up with something, I want you to know that me telling you is not my endorsement of it. It's me living up to my obligation that I have to do, right? So you want to let them know that, prepare them for it. Let them know it's coming one day. Let them know the discussion says nothing about your view of it, and let them know the decision is theirs and only theirs, right? So keep your clients advance notice of what's coming down the road, because you know it's coming. Show them that you're concerned about them as a person, right? Be familiar with the things that are important to them. We talked about the example with the mom, right? In stage 2 cancer, right? Family, right? You want to know their hobbies, their interests, right? And if their interests happen to be 1 or 2 of these things, then you know that you have a client that you're going to be lifetime friends with, a lifetime bond with, right? It's been statistically proven that those who are LSU fans and Saints fans tend to be more client-centered as lawyers and tend to be stronger clients, right? So just consider that. Their hobbies. This is important too. I like this quote from Lil Wayne. I'm in Louisiana, born and raised, so you know I could be in Houston, but it's not about it's not about where you're at. Sometimes say it's not where you're from, but I wear Louisiana on my sleeves. But I love this quote: "Never apologize for what you feel is like being sorry for what is real." And the way it resonates with me and how it can resonate within our profession is, don't try to talk like a lawyer. And we talked about that before, using these words that are just completely boring and dry. I think it's necessary to use legalese, but you want to use it whenever it's convenient. And you want to make sure and break it down and talk, right? Talk to them. But more importantly, don't try to talk like your client. Look, we all have differences, geographically, culturally, tongue-tied, within our ethnicity. But it's important to you to be yourself, right? I do not, and I said this before, I've never been to Virginia. It's one of the few places I've never been, the entire state I've never been. But I will not try to talk like my perception of people from Virginia. I know very few things from Virginia. I know, and I know Chris Brown is from Virginia, but I'm certainly not going to try to speak and talk and act like Chris Brown, right? Or my perception of what I think, and I'm certainly not going to think just because I see him, I think all people from Virginia act like that, right? Not saying how he acts is good or bad. So whenever you come to Louisiana, for example, you come to Louisiana, don't try to say words that we say. I mean, it's good that you recognize you know what it is, but don't try to talk like us with an accent or whatever the case may be. Don't do any of that, right? Be yourself, because it can be seen as insulting. Now, you may have the intention to connect, right? But it may come off as mockery. So you want to be very, very careful and cautious. In fact, I find it more connecting to just go ahead and be honest and say, you know what, I really don't understand that. I really don't. And that, like in Houston, I've only been here a year, and I'm very, very upfront about stuff I don't understand. And I think it actually brings me closer to clients, because usually they laugh and make fun of me, but it's okay to be the butt of a joke. I'm okay with that, right? Like, oh, you don't know what this is? Ha ha ha. Or you don't know certain, whoever. And we'll laugh and have a good laugh over it, right? Or the way I say certain words, and they'll laugh at me, and that's fine, because it builds a relationship and connects. So don't try to talk like your client. Be yourself, because it'll get you a lot further and a lot closer to your client. Be mindful of differences. I am an 80s baby, and this song was made in the 80s, and so I'm going to show stuff like that. But when I say be mindful of differences, what I really mean is gender differences, race differences, class differences, education, break it all down, sexual orientation, religion, right? There are differences that may affect our communication, right? If you have a client that is transgender, you want to be very, very careful about the name that they prefer to be called, right? And you want to have a conversation about how that may play out in court. Know your judge, know these things, and have this conversation with them, right? Because if you're forced to have to call, if you're forced to have to recognize a name that they don't identify with, at the very least that client, and if it's really forced to that degree where you can't bury through to the judge, at least the client understands that you tried. At least the client understands that you value them as a person, right? So you want to be very careful about that. Scenario 4, lawyer's initial client meeting. Lawyer's initial meeting with client. Lawyer hands the client a document, tells the client to read it. The client looks at the document, appear to be reading, and then hands it back. The lawyer then begins to ask about the document. The client answers with very vague questions appearing to be confused. Stereotype, right? And the stereotype fits that we don't care. Obviously, if that client looks confused, there could be a mental impediment there, maybe even a physical impediment, right? Maybe they don't have glasses, and not every client is forthcoming to tell you about their physical or mental impairments. Some of them are not as forthcoming to do that. So you're going to be very, very sensitive to potential limitations, right? Cognitive limitations, age, mental health, education, right? Emotional or physical abuse. Some of you may say, well, Kenneth, how do I deal with that if it does exist? What if they are honest with me about it? Well, if they don't disclose to you, I think a good thing is to be very observant about things. Whenever you're an initial client, you should be memorializing everything anyway, but you're also memorializing the things that you see. Are they rocking? Are they shaking their hand a lot? Are they doing certain things that may be indicative of maybe contracting a social worker or contacting a social worker, right? Emotional or physical abuse, right? Age, maybe they're a client that is, your parents' generation, and they're a little bit, I don't like to use the word old, let's just say more seasoned, right? They're more seasoned than you are, and maybe there's some distrust there with your age, right? Consider this. Maybe if you don't have the experts, or maybe you don't have the staff to accommodate these differences, but you do have co-counsels. Maybe your client's a man and doesn't like women. Despite your views about it, maybe you have a woman as a second chair. Maybe you have someone, maybe you can't get a social worker, but you may have a coworker that has social work experience in their background, right? Use the resources that you have. And now this is the New Orleans coming out of me, because in New Orleans, we didn't have many resources at all. And so we had to get very, very creative as far as all we had was each other. And so we had to borrow parts of each other that may have complemented and felt that need. And I'm very proud of the efforts we did, right? In order to do that, because it taught me a lot to rely on what you do. Sometimes we're so focused on what we don't have, we don't stop and look at what we maybe have that's right in our face. Okay, so think about these things as solutions to solving these limitations. Scenario 5, and I'm going to get a little bit quicker with these. Lawyer is meeting with client to discuss a bond review hearing. The client obviously does not have confidence in the lawyer. The client says that he wants to contact family about getting a paid lawyer because he thinks the lawyer is not doing his or her job. The lawyer explains that she has looked into all the areas that will help with the bond hearing, character references, etc. And it's a good motion. Client says, so am I going home? The lawyer says, you have a good shot. Client keeps pressing. And then finally he says, yes, you can expect to go home. Now, that's a very dangerous situation because that falls within the stereotype. If you're giving a client a guarantee that you're not sure about, even though it's a great motion, and even though this judge has a great history for entertaining these motions, maybe he's a progressive judge and he's doing these things, right? And he's progressive prosecutors. I think it's still dangerous to stop short of guaranteeing things, right? Because it can fall within these stereotypes, right? That, either that we're aligned with the court and state, we knew this all along and we were just pumping them up, right? That we're incompetent, we didn't know, and we just throwing up things. You don't know your court, you don't know your judges. So you want to be very careful. So if they're pressing you, you might want to say, look, I'm as confident that I can be, right? That we're going to prevail. But there are factors that are outside of my control. And in order to assume those factors, that would make me a bad lawyer. That would make me a bad lawyer. That would make me dishonest to you. So I'm going to stop short of guaranteeing to you. I'm as sure as I can be, right? Because there are things outside of your control. So you want to make promises. Don't make promises that you can't keep, but you can make some promises, right? If you break a promise, you look like this guy. For those of you that Game of Thrones fans, right? You look like Littlefinger, right? You don't want to look like him. Instead, you want to look like, and I'm sure y'all might know who I'm going to say, Jon Snow, right? No matter how small, you build trust. So what are some of the small promises? I don't know, maybe following up with a visit, maybe calling their mom, calling their dad, making these calls that you're going to do, filing a motion on the day that you say you're going to file it. You may not litigate it on that day, but you certainly can file it, right? So little things like that do matter, right? Think about that movie, Just Mercy, for those of you that saw it. Jamie Foxx played the gentleman that was wrongly convicted, right? And you have, you have the protagonist of the story, and he's this great lawyer from Harvard, great heart, moves down to Alabama to represent him. And he's doing everything right? But Jamie Foxx still does not trust him. He didn't gain his trust until he went to go visit his family. And that changed everything. Because when he came back to jail, Jamie Foxx told him and said, you visited my family, you saw my people. It means a lot. And then from there, that relationship blossomed. Those small promises matter. Keep your client updated and maintain regular contact. What does that mean? You know, give them sufficient information. Let them know what happened, even if nothing happened. Sometimes that is what you're telling them. Nothing happened, but this is what I'm going to work on. And on a positive note, but these are some things that I think we can do, right? I thought of some questions that I think we can ask, right? So it keeps client from turning elsewhere, like jailhouse lawyers, right? If you keep the more information you give them, the less they turn other places, right? It keeps them from feeling the need to test you, because sometimes they do. And I ain't gonna lie, I don't blame them. I don't blame them, especially for those that have been arrested multiple times, right? Some of you may feel like you're playing a game with me, but it's not playing a game. It's their life. You're going home at night. They're not. So, you know, kudos to them for testing you. I would too. I want to make sure that you are fireproof, right? And there's nothing wrong with that. So understand that perspective before you judge it. And it saves time in the long run, right? It saves time in the long run to keep your client advised from the get-go. Now, lawyers in court with a preliminary hearing, after the officer testifies, the government argues that there is no probable cause. Judge turns to the lawyer. The lawyer says they have no argument, right? Now, I know some of you may say, well, sometimes we don't. The case is horrible. Well, probable cause can also be used, right, as in a bond hearing, right? Maybe there are factors that go towards determination of bond, like weight of the evidence. The judge, I may not have an argument towards probable cause, but I do have some argument for consideration that goes towards weight of the evidence, which is something Your Honor can take into effect. The point is, don't fit a stereotype that you think they're guilty. Instead, show them that you are a fighter, right? Take advantage of opportunities to argue and argue with conviction. Now, take this presentation. Now, granted, I'm a little bit wordy and I can go on, but the one thing you can't take away from me is that I'm not passionate, right? And I say it with conviction because I really believe this. I have my days where I don't feel like doing and getting up just like you do. However, I believe it, right? And I make sure that I align myself with people and things that remind me of why I'm doing this work every day. And that is something that keeps this passion burning. And I challenge you to do the same thing. Because if I sat there and I was monotone and be like, well, take advantage of opportunities to argue with conviction, right? And I just want to make sure that you understand you do that, because clients may not like it. It may not be great. Are you going to have much faith in me? I'm just some person in Texas with maybe a Louisiana accent that just goes around running his mouth to you otherwise, right? No, you have to argue with conviction, right? To make them show them that they matter. Their lives matter. We want to say lives matter. Show it. Show that clients' lives matter. Scenario 7, seated in a courtroom. This may be familiar to you because it's familiar to me. Walks in the courtroom, court begins. Prosecutor walks in, lawyer stands up and says to the prosecutor, hey, Jim, good seeing you. How's the family? Let's plan on meeting for golf soon. The lawyer and the prosecutor exchange pleasantries, then the lawyer sits back down. There's nothing wrong with being nice. I'm not saying that prosecutors, you walk in and say, F you, don't talk to me, right? Some of you may feel that way. But there is a difference between what your client sees and what the actual reality is. All right, and think about what that stereotype is reinforcing. It certainly enforces number 1. So be conscious of how you relate to others. That includes judges, that includes prosecutors, that includes police, that includes probation officers, that includes all of them, right? Now I know that some of you may have gone to school with them, you may have worked with them. In Louisiana, like in Houston, I don't know many people, so I don't have that issue. But in New Orleans, I did. A lot of these people I went to LSU with. And it was tough, right? So sometimes I had to have that conversation because we love to talk about the Saints. And one thing I had to say was like, look, you'd have to have a conversation with your client or the party, that the judge or whoever it is, and maybe even both. Sometimes they may say, look, man, I understand, but look, not in court. I really don't want to have those conversations in court because I am concerned with my client things. And my client is number 1 in this professional space. So I'll say hi, I'll say hello, but anything beyond that, can we just kind of keep it low, keep it there, right? Talk to the person. And if they really your friend or they really cool, they're gonna understand. Your client, tell your client like, look, you're gonna see me walking there, you're gonna see me shake hands and I'm gonna say hello, but I don't want you to get it twisted. I work for you, right? And I'm getting information about you. You may not hear it, but I'm asking you to trust that these pleasantries does not mean I work with them. It does not mean I work for them. So I want to make sure you understand that, right? Have that conversation with them. Dealing with abbreviated meetings. I'm about to have this challenge in the last 8 minutes, right? Abbreviated meetings. You want to explain the purpose of the hearing. Explain the importance of getting the necessary information for that hearing, right? So you want to make sure that you get the important points out, because a lot of times you may have 5 minutes, 10 minutes to speak with that client, especially for those of you that do bail hearings, and have a short amount of time to get that information, prepare the argument, and then go before the judge. Some of you are meeting them in the first time and doing all of that. I know that, I've been through it. So, you know, a conversation may go like this, right? You may say, look, I want to make sure that you understand that I value everything you're saying. But right now, a judge is about to come out, and he's going, and the purpose of why we're here today is to see the fastest way that we can get you out, right? The fastest way you can get you out, whether that's the lowest possible bond or basically what they call a free bond, ROR or PR, whatever y'all use. And so I have to ask these questions. It may sound mechanical, but it's not. It's just important what the judge continues. So I'm going fast, but I want you to know I'm going to follow with the visit, and we're going to talk about some of this stuff in detail, or another lawyer will. I'm going to get this information to another lawyer, okay? And then you go through that. Explain the purpose, explain attorney-client privilege, right? Or jail calls being recorded, the essential things, but let them know that you're interested in talking to them, right? And you're going to get their concerns, or make sure someone else get their concerns, preferably the lawyer that's assigned, whether it's you or someone else, right? And the main thing is follow up. If you're going to do it, do it. If you're going to tell them, do it. That's the biggest thing, because they're waiting for that. Because a lot of them, they know it's close to, if they know you're trying to get information to get them out, go do what you do, right? They want to make sure that they want to make sure you're prepared, but you got to relay that to them and relay it with conviction. So in summary, with the hurdles, knowing, educating your trade, right? All of these things, we talked about these stereotypes, and these hurdles are basically a summary. And there may be more that you guys may think of. You know, presumption of innocence, advocate, don't access, avoid the what happened question in initial client meetings, handle plea discussions, right? Let them know up front, show your client, show concern, be yourself, keep your client updated, dealing with meetings under time constraints, being conscious of how you relate to others, showing that you're a fighter, sensitive of these limitations, being mindful of differences. There is one more thing that I would like to discuss, right? When we talk about benefit, well, first, you know, by doing all these things, it creates, you know, reliable information from your client, and instills their client confidence, and it minimizes their constant need for reassurance. But most importantly, it restores faith in public defenders, right? It transfers that negative image. You start to be the change you want to see, and you start to change their perceptions, which is the most important thing, which is key, right? That is what the purpose of identifying these hurdles and overcoming these hurdles will do. Now, before I get to questions, there was a slide that didn't save, unfortunately. So I'm going to discuss it with you. A lot of you may say, well, we're in COVID. So how do I deal with that in COVID, right? How do I deal with that issue in COVID? And COVID does not change how we communicate with our clients, but it does change how often or when we communicate with our clients, right? I'm aware of that. So when you hear about COVID, I do want you to understand these principles still apply, even if it's unfortunately through a Zoom call, even if it's unfortunately with a mask on, even if it's unfortunately through phone conversations. But there are a few things I do want to keep in mind. Whenever you're writing clients, you may have to get more into that. Make sure you're including that it's private and confidential on the inside of the letter, whether it's a watermark, and on the outside of the letter, indicating that it's legal mail. Will that keep people from snooping into it? No, but it does provide certain protections, right, of identifying this confidentiality. So you want to consider that. You want to consider on your Zoom calls, right? Trying to see if you can arrange for Zoom calls with the department, right? With the sheriff's department or the detention departments in your jurisdiction. I'm not sure where they are on that, but those are some things that you can consider in doing that, right? And some of you may say, well, there's still going to be people there. And that's true. No matter what, the level of information for those, especially in jail, is going to be limited. But maybe you're working out signals with your client to show high distance, right? Maybe if there's a deputy and maybe you've written to your client, tap on your arm and I know how close he is, right? And that is influencing the level, because all you can see is here. You right now, none of you know who's here left or right, and there's no one, but still, right? You want your client to be able to have a way to identify with you how close a deputy is. So maybe maybe you feel more comfortable getting in a sense of information if that's the case. That's just a suggestion, right? I'm not the authority on it because I'm still figuring it out myself. Right? Some of you securists on phone calls, I still would avoid talking about sensitive information because they're still being recorded. And I would imagine that if prosecutors use them then, they're using them even more now, knowing our restrictions. And one thing I would say, some of you may say, well, I can't do Zoom calls. Well, if you're doing it through court, you know that it exists. So maybe having motions, right? Arguing motions for pretrial conferences, having pretrial conferences in court for the purposes of consulting sensitive information about your court that you wouldn't otherwise be able to do. You can't go to jail. You can't do a Zoom call through jail. So the only other thing you're left to is a pretrial conference to properly advise your client. Remember, one thing you can hold over a judge is Boykin forms. If judges want to move their cases so much to a Boykin proceeding, you can't properly advise your client. Your client can't place a check mark without an appropriate pretrial conference. And you want to litigate to have it as soon as possible, right? And to be able to do it through court. So you can litigate the issue as well, right? To avoid invalidating a resolution if there is a resolution, or that your client has been advised before electing to go to trial. So these are some things to consider during COVID to start to make everything we talked about a reality, right? Unfortunately, until face-to-face communication, that may be restricted, but the essence of this won't be. So I know that I have talked and used up a lot of my time, but as long as you'll have me, I'm open to any questions, and it's been an honor and privilege to talk with you.
Well, thank you, Kenneth. It was an honor to have you as my guest. And I took a lot of notes, and I'm going to be asking you several questions because I'm going to ask you questions as long as you want to answer them.
Sure.
This webinar is going to be replayed, and I'm sure others will have questions, or hopefully I can get everybody's questions answered with mine, because I'm sure if I have them, other people do too.
Sure.
But if you are watching this replay later, feel free to write something in the comments, and you know, Kenneth and I will be keeping an eye on it. We'll make sure to try to get you an answer. But yeah, I just wanted to actually make a comment. You mentioned kind of the 6 degrees of separation thing, you know, the information getting you know, basically wrong by the time it gets to the news media. I mean, essentially wrong. I don't even, you know, believe most of what's in the media anymore, but that's a separate issue. One time I was in a courtroom and I was watching a murder trial, and something happened in the course of that trial, and it was a big deal where I was, and there were in the news every day, and there were a lot of reporters there. And about 20 seconds after something happened in the courtroom, it was on Twitter. The person sitting next to me showed me a tweet, and it was just wrong. I was sitting in the courtroom, and this tweet was just wrong about what happened in the courtroom. So I just wanted to point that out, because I know exactly what you mean, and that's 20 seconds from somebody that actually is in the courtroom and listening to it. So all the people
Right.
saw that message, you know, it was just completely inaccurate. And I wanted to talk about what you had mentioned about the phrase, what happened? I'm sure I've probably said that. I hope not, but it sounds like something I would say. I try to be careful about the questions that I ask clients, and I'm sure we all do, but it's important to hear these things that you're saying. Sometimes I say things like, so just to give you background, in Prince William County, about 2.5 years ago, we started to get body cam in basically every case. I mean, at least the Prince William County officers, but some of the cities and towns at the time didn't have it. So what I would say to a client is, okay, I would tell them, I'm going to get the body cam footage. I'm going to see everything that happened there. What is the body cam going to show? I have never, not once, had a client tell me something that was inconsistent with what was on the body cam. I mean, there may have been, it may have looked a little worse or a little better, but it was, I mean, they told me what was going to be on there. So do you think that is an effective question? And feel free to tell me if I'm wrong, but is that a good way to ask something like that?
I think one of my biggest fear, as far as placing them in the zone of what happened, and I think that's where that question lies, what may be on the body camera, is the locking them in to the version of events, the same way of asking repetitive questions as to what happened. Because think about one thing, it locks them in, but it also could be a triggering traumatic effect to them. And I don't mean to sound, I'm not a psychiatrist, I'm not any of that, but think about what they've been asked for if they've been interviewed by a client, by a police officer. You know, well, you know, what do you think this witness is going to say? We got it on body camera. We got it on this. We got it on that. And when you're trying to separate from the system that they've already been exposed to before they ever met you, when you're asking those questions, even though your tone is different, even though your motives are different, you can fall into that ground of doing that. And so that is one piece to it where I tend to stray away. A better way I may ask is like, look, on the body camera, I mean, if I got to the point where they're trusting, we're talking about body camera, do you know what a body camera is, right? I don't assume that they know that, right? Do you know what a body camera is? And explain what it is. And sometimes throw yourself under the bus. Like, look, I didn't know what a body camera was for the longest. It's like these little things that they click on and click off, and then it shows. Did you ever see an officer do that? Did they ever do this like that? And that's important from the very beginning, because what if they are secretly turning on and off what you want them to see? So I think I think that the instincts are right, but the phrasing of the questions can be a little bit more effective to actually use the investigative source. So did you ever see them do that? Click on and click off? Did you ever see them grab on their area right here or in the middle? Did you ever see them do that? How many times you see them do it? Did you happen to notice whether a light came on or did a light come off? How many times, how were they around you in the body camera? Like, how many times were you around this officer as he was doing that? And see, as you're doing that, you're getting information as far as what the body camera is going to show. You're getting your camera, but to ask the vague question, what is the body camera going to show? So you're asking these questions that are investigative towards there, but it's empowering that client from a perspective of investigation, rather than what's on there, you were there, right? And so you want to try to get out of that zone. That would be my take on it. It's just a danger of it. I'm not saying that it's going to always be, that's what's going to happen and clients are going to feel that way. But it's just really trying to avoid the danger of the presumption of guilt with that.
Okay. Well, I'm glad I asked. And I think the thinking, and a lot of lawyers probably think that if we mention the body camera footage in the beginning, that, maybe it will get us quicker to well, I don't even want to use the wrong phrases, but get us quicker to, what actually happened or what the client's version of the story is, instead of going through, 30 minutes of story or what the client says. I don't want to use the wrong phrasing here, but that's why we're having this conversation.
Right. Mm-hmm.
And then find out, when you get the body camera footage, that it's completely the opposite or not in any way close to what the person said. So how do you go about conveying the information to your client that I most likely will see the footage of what happened here? How do you do that the right way? So you tell them, look, this has been recorded. I'm going to get it. So that you can try to be as efficient with your, questioning. Do you understand what I'm trying to ask?
I understand what you're saying. I start with what I have rather than what I don't have. And usually what I have is probably some version of a report I'm assuming y'all get, right? Like a summary, or maybe you get the full report. I'm not sure, or at the very least, the initial report.
We generally get at least the criminal complaint in the very beginning. We don't, in Virginia, things are changing, but we don't automatically get police reports in every case.
Oh, wow.
I mean, not in the beginning, no. And yeah, so.
What information do you have as far as what they determine probable cause from, as far as in setting a bond? Is it just the complaint, or is there some other extra document that you get? Because usually just to have that kind of reference. So whenever you're going into your visit, there's something to start building that investigative block, because that's why I'm asking to build on to your question.
So it would be the warrant, the criminal complaint, the pretrial services is what we call it in Prince William County. They interview the client in jail to determine things like substance abuse history, criminal history, but we don't get to see the actual record until we get into court. The prosecutor will let us see it, but all we have in the beginning is just the warrant and the criminal complaint.
I think when you start getting into the body camera piece, right? Whenever we talked about knowing your trade and knowing these things, I think you talk about what you have, but I think it's okay to talk about what you're expected to get. For example, like, look, in this case, we're expected to get a few things that I don't have right now. This is what I have, and I want to just kind of go over it with you if that's okay. But there's some things that I won't have that usually we get in every case, something called body camera. Do you know what that is, right? That way you're putting it in their mind that it's coming, right? You're putting in that client's mind that these things are coming. You don't know when it's going to come. It may take 2 days. It may take 2 months. You have no idea, but it's coming. Right, rather than it's going to show everything. I don't want to say it's going to show everything, because we don't know that, right? You don't know if that officer, it's putting a lot of trust in that officer. that they're actually showing everything, right? Is getting a lot of trust. They're actually going to turn it over. There are situations where they haven't, right? And that's really what I'm getting at when you're communicating with them. But whenever you start to ask like just little questions of like, the complaint says, this is what the government is alleging, this is what the state is alleging, that this is the complainant witness. What can you tell me about them? And you can start using those investigative bricks, right? Not what can you tell me about them, but does this name ring anything to you? Do you know anything about them, right? Do you know anything about, it says here you were arrested by this officer. Do you remember how that happened? I mean, is that accurate? Were you arrested, in your view, do you recall how you were arrested? And you start to kind of slowly get into these things and using these as blocks, as comparing them, right? You're using this as investigative blocks. So when you do get that body camera, then you're looking at, you still have these investigative blocks that hopefully you're giving to an investigator too. I'm not sure how y'all work with investigators, but I'm using basically this information that I'm getting from my client as a building block to have some investigation, right? Mm-hmm. And then once I start getting that initial investigation in, then when that body camera starts to come in, then I can start having more of a comparative source, rather than that way I have some information to go off on to know what's accurate versus what is inaccurate, right? Because that client, when they're telling you things, when they're sitting there telling you whatever they're telling you, right? When you're asking that what happened, yes, you don't know what it is right, you don't know what it is wrong, but more importantly, you don't know what their motivations are. It kind of goes to, why would they tell me something different? Because they don't know you, right? They don't know what you've walked in. You may be working with the state for all they know, right? For a lot of clients, they don't know that. And then there are some clients that, maybe they are telling you something, but it's not intentional to be inaccurate. Maybe they really don't remember. Maybe they don't, we don't know a lot of the things that play in fact. And really what this is centered on is not losing that relationship, but still building that investigative fact source, right? Using them as investigation without actually creating that judgment zone. And sometimes it's a blurry line. I get it. It's a blurry line. You want to get as much information as you can. But I tend to stray away from the body camera, is going to show this. The body camera is going to do that because that puts a whole lot of faith in an officer. It puts a whole lot of faith in that, right? And I don't.
Mm-hmm. Mm-hmm. That's a good point. I'm glad that I asked. I'm sure other people, well, hopefully probably had the same question.
It's hard. It's hard. It's hard.
And I mean, even if you keep all these things in mind and go into a client, initial client with the best of intentions and, obviously with experience, and the more times you do it, the better you get at doing these things, but you're still probably going to come across people that just don't trust you. So let's assume that we go into a client meeting doing everything that you talked about, doing everything right, handling everything the right way, the right body language. Is there anything else you can do? If you know the client, you can tell sometimes when people don't trust you. How would you suggest trying to get them to open up? Do you say things like, I need to know everything that happened in order to do the best job to represent you, or I don't even say these phrases, people watching, but I don't want to be surprised in court. How do you convey that to the client, without sounding rude or,
Well, gaining that trust isn't always directly tied to a legal conversation. A lot of times it's tied to a personal conversation. If they're telling me stuff about themselves, finding things that I do connect to, even if they are giving me a narrative about what happened or didn't happen, finding things I could connect to. If they said something about, hey, I was walking in and my mom was playing a game or whatever, and like, oh, okay, what game? Little things like that that's showing a nugget of connection, because you're building little bitty evidence of trust. Now, I know that they may not trust you, maybe it's where you're from, how you look, but certain things there's certain things that usually if you listen long enough, there is something that you can connect and resonate to. It's just that we're so focused on our goal for the meeting, so focused on that we have this closed-minded book of this is what I got to get done, this is what I got to get done. Okay, I hear you, your client's elaborating, going off, and then we cut them off, right? Those things are hurting you. Those things are hurting that representation, and at some point is going to affect your quality. So listening to what they're saying, and also active listening, right? And responding and using their words. Right? If a client says certain words, and it's like, look, and I just want to say this in your words. That way it's not coming off as mockery or trying to be them. Like in your words, it was a baby mama, right? It was a baby mama. So how far does this relationship go back? And also making sure that we're asking the questions that aren't, for example, it amazes me when we get a report or arrest warrant, and it's kind of like using the skill of cross-examination where you're just repeating the direct, right? Why am I just repeating the things in the report? I want to know information that's not on the report, because that report is written with a certain perspective and with a certain goal, which I have to say that I believe is ultimately to verify their arrest, to support their arrest. The point is that a lot of police officers, I'm not saying all police officers are bad, I'm certainly not saying that, but all the body cameras I watch, they're trying to see if an element fits a crime. They're not concerned whether the element doesn't fit a crime. They're concerned with how to make it fit, right? If you're watching and you're listening to the side conversations with the officers, and they may have the best integrity and their tone is nice, they're treating the client nice, but their goal shouldn't be to make an arrest stick. Their goal should be also to let it go if they don't, right? It's not just to protect and serve the innocent, it's to protect and serve the falsely accused, which are also innocent. So the fact is that you have to make sure you have that right mindset when you're listening to your client too. You know, it's natural. What I'm suggesting in this presentation is to do something that's completely unnatural, because it's been something that's been trained in our DNA. Everything that I'm saying is going to sound like, oh, I believe every client is innocent. Oh, I believe every client is this. That's not what I'm saying. I'm certainly suggesting that how we communicate with a client and treat them like a human being, and actually the principle of how we advocate, rather assess, right? And in order to advocate, has to change, right? Or it should change to be truly client-centered. And I think a side benefit from that will be the information that you get and asking these questions and asking these certain things. And I think that's going to relay. So, you know, whenever you find, if, you know, as they're explaining these things to you in your investigative questioning, you know, don't ignore the things that you may connect to, right? I mean, if they speak to your mom, you have a mom, you know, I mean, or you've had a mom or something, right? Something that can resonate with them, right? And there's always something. I'm not saying don't look for everything to connect, right? Because then it just comes off showy and you're trying too much. Pick one or two things that they may have said that you can connect to, right? And you know, and stopping a moment acknowledging that is going to continue to build trust, right? Now, some of you may say, well, that trusted me about his mom. How's it trust about legal information? I think that's how it starts. That's how it starts. If you can understand them and where they're from and where they've been, then chances are they're going to trust you more. Because I've been a person where I'm trying to look at whether I've been that person, because a lot of times there are people that look like me, right? And I'm not exactly forthcoming. I'm a people person, but I'm not forthcoming until I know that it's a safe space. I'm not. Even if everything I'm saying is true, I'm not, you know? And so you have to understand that, you know, going into that.
Yeah, that makes a lot of sense. Not just in client relationships, but in any relationships in life, trusting people. Yeah. But so what if you don't, what if your client does not think that you understand where they are coming from? Because, you know, if I go in to talk to a client and you go in to talk to a client, you and I look different, right? So that client might not believe that I understand. How do I let the client know, or how does somebody of a different race or gender let the client know that they understand without sounding condescending? Like, you know what I mean? Maybe we don't even use the word understand. Maybe that's not the appropriate word.
Empathy is probably what we're looking for, but if you don't understand, you know, invite them to take the floor to teach you. You know, I have no problems saying, look, I can identify with that. I'm sorry that happened to you, but I can't identify. Can you explain to me? Can you, if you're okay with it, you know, the floor is yours to tell me, how can I understand this better? Like, what is it? How has this impacted you? Right? Because you may not know, even though it may seem unrelated to your litigation, it may be. It may be. In other words, I'm not necessarily going into a meeting with the goal to just, let me create this narrative. Let me find this narrative, right? Because to some degree, that's encouraging me to invent a narrative if I'm walking there with the goal of having a narrative. The narrative is a long-term goal throughout the life of a case, whether that's 2 weeks or whether that's 2 years. What I'm looking at is I'm learning things about that client, right? And I'm memorializing things about that client that may explain certain factors, right? What are my facts that are beyond change in the case, and what are my facts that that are arguably changeable. And I'm seeing where my client's narrative falls in between any of those things, right? And so as I'm learning these things, I'm living in the moment with my client, right? Like, look, I don't know how it feels. Like, for example, I'm a blessed person that I'm a product of parents who are still married, right? So one thing I can't understand is if someone who got divorced, like if they were divorced at 16 and they've been living in that household, I don't know what that looks like. So I'll tell them, like, look, and some of them, and don't assume the emotions, right? Because they got some people that say, look, my parents weren't happy, and I'm happy to see that they're, I'm fine. I grew up fine. 2 Christmases, 2 blah, 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 blah. And some of them say, man, honestly, it was hard. So what do you mean by hard? The best follow-up question with a client is the best follow-up question with a jury. What do you mean? Right? When you say you are hurt, what do you mean? And tell me more, right? That's the best follow-up question ever. I had this issue recently with a client. She was everything I wasn't. She was a 18-year-old Hispanic young woman, and I could not break through to her. I could not get her to, one, I believe it was a male thing, 2, an age thing. I'm 37, but I'm not 18. I couldn't relate age-wise. And it took weeks of getting to know her, asking little questions, even clowning her about the Saints being a better team than the Houston Texans, right? Little things even there. And over a few weeks, I started to get pieces of the story. Turns out this young lady at 18 had 2 or 3 miscarriages. Turns out that this tattoo that was on her arm was a tattoo of the name that she was going to give her most recent miscarriage. Turns out that she never sought therapy because she grew up in a household where her mom, she didn't know her dad, despised therapy and thought that therapy was just more of a trick, and people that grow with that belief system, it's a legitimate belief system. And they believe that, right? In their family, it's a legitimate belief system. And she has a mom that tells her that all the time. So she never got help for that, right? That comes over time. And you know what I had to do? I had to actually reach out to a social worker that would come with me on 2 or 3 of these visits. So I had to use people around me to get to that. Sometimes you can't do it by yourself. Mm-hmm. You can't do it by yourself. And I'm not suggesting that just, it's a Black client, let me go get a Black person. I'm not suggesting that. But there may be some part, it could be some point where you may need someone that looks like them to borrow on a case, but it could be just someone that can identify with that experience. But I would ask the client before you do it, little things like that. And be like, look, I still, either A, invite them to have the space. If they reject that space, it's like, look, I want to be the best I can be for you. Is it okay if I have someone, I think I know someone that may understand this a little bit better than I do. Do you mind if I bring them? You mind if I invite them? Is that okay with you? Empower them to make that choice, right? Empower them to make that choice. And that can be another suggestion.
Okay.
So I didn't mean to go into the theory first, but theory and then the suggestion of how you can get around an issue like that possibly.
No, I mean, I'm glad that you said that instead of just, bringing a person that you think would be helpful to actually, give the client a choice first. And I'm sure most would probably appreciate that. Yeah.
I think, we need to involve our clients more, right? There are certain decisions only they can make, but there are certain decisions that even though legally you may be able to make on their behalf, it doesn't mean exclude them from the conversation.
Mm-hmm. Gosh, I have so many questions. I wrote down the phrase "makes sense." I was actually at this event yesterday, and the group, it was a Chamber of Commerce thing, and they were talking about how certain expressions can be holding you back. It wasn't in the context of what the client, but they said the phrase "makes sense." Does that make sense? Basically sounds like you are insulting the person. So.
Yeah.
You had mentioned making sure that they understand, what you're saying, and if they look confused. So how do you make sure that they are understanding? Because I mean, it's very important. They have to understand all the implications of a plea agreement or what's in the pre-sentence report. So how do you ask that question the right way?
I think the "does the make sense" comment might be more of a tick. Sometimes people use that as a tick, like an and so. You know, I may say, oh yeah, does that make sense? Oh, that does make sense.
Yeah,
Sometimes I say that because that could be a potential answer to your question. Like sometimes I tell clients, like, look, I have a tick sometimes, and I don't want to offend you with anything. If you hear me say that, does that make sense? I had these conversations with my mom. I could say, Mom, my favorite color is blue. Does that make sense? And they may laugh, right? And it's just like, it's just something I can't help. I can't control. So please don't take offense if I ask that a lot, okay? So you can, that's one way. Because if it's a tick of yours, then just, man, don't hide your imperfections from your client, right? We're certainly asking them not to hide theirs. So don't hide yours. Don't ask the client to do something you're not willing to do. The second thing is what I would ask is like, look, you know, I ask a lot of questions like, look, man, I'm definitely not trying to assume that you don't know anything. I qualify a lot of stuff. Like, I'm not assuming that you don't know what this is, but, you know, a plea agreement, have you heard of it? What do you think it is? You know, what do you think it is? I know we all have different versions of what that is to you. What is it? In your experience, what does a plea agreement mean, right? Some of them will tell you flat out, I don't know what it is. You know, I've heard the term used before, you know, but let your tone emphasize the point rather than your actual words. You know, look, I mean, plea agreement. Have you heard that used in court? I think I'll lead with what I think it is. I may say, look, generally, I've heard so many different versions of what people think plea agreements are. What do you think they are? Right? Or better yet, you know, these reports, you know, I mean, I've heard people say, you ever heard people say reasonable doubt? You ever heard people say the state has to prove it? What does that mean to you? State has to prove it. What do they have to prove? You know, I mean, you know, you heard them, you heard the judge in court, they said, what are the elements? State have used the elements. What do you think the elements are? Let's talk about it. You know, what do you think the elements are? You know? And if they snap back and be like, well, you're the teacher, you're supposed to know. I'm like, yeah, I have my ideas, but I just don't want to exclude you from my ideas. I don't want to exclude you from anything that you know, I want to make decisions with you, you know, as well as for you. And the only way I can do that is to understand what's in your head, right? I just want to understand what's in your head. That's all. You know, I was like, I don't want you to take offense by it. I just want to understand what's in your head, because I feel like we can go a lot further for that, right? Like we can go a lot further with that. Is that cool with you? Is that okay with you? You know, that kind of thing. I think just kind of, you know, understanding that, like, right? Like for example, if you're talking, it's the same thing if you're talking to your significant other or anything. I just keep using that excuse because, you know, for those who are quarantined, probably spend a lot of time with their significant other. You know, we love in different ways, right? A lot of people like to say, what is your love language? You know what love, everybody knows that love is a word. But when people say love, we think of different things. You hear it all the time. Same thing with presumption of innocence and the burden of proof and all of that, right? Clients have heard it the same way we've heard it. And a lot of times we assume because they've been arrested before, then they must know what love is. The same way we'd assume you've had a lot of boyfriends before, a lot of girlfriends before, so you know what love is, obviously. Well, maybe you've had a lot of girlfriends, but you haven't been in love with all of them, right? And maybe he's had a lot of lawyers, but none of them took the time to explain it. So really it's just having the conversation as in, what do you think it is, right? What do you think love is? Like maybe love is a word to you to hear it often. Maybe words are actions to you, right? Maybe word is quality time. I don't mean to go through the book, but you know, so it's the same thing with our clients. So, but I think you got to be more cautious of how we say things rather than what we say. That's the way I think of it.
Yeah, that's a good point. You mentioned a minute ago making decisions with the client as well as for them. But one thing that we all know as attorneys, it's their decision whether or not they plea guilty or not guilty. And you've probably had this a lot. It happens to me a lot of the time. They say, what should I do?
The big, and then the big three, right? The big three of what the client decides, whether to have a judge or jury trial, right? Whether to plead guilty or not guilty, and whether to take the stand or not take the stand or not take the stand. They only do. And then there's this debate as to, we decide everything else. But I didn't mean to interrupt. I apologize.
Oh, no, you're fine. But that's a good point, the jury versus non-jury. I mean, and, you know, we explain what the benefits are of a bench trial versus a jury trial. It's ultimately up to the client. You know, in my experience, I have never had a client that I can remember that went the opposite way of what I thought we should do. Of course, it was their decision, but I mean, there's a fine line. I mean, how do you explain to them, the differences, the pros and cons, without trying to, influence them and force them to pick one decision? And when they say, what should I do? How do you respond to that?
It's a very, very, very tough question that I think is always going to be something we struggle on because it's so case by case, right? I find that these situations are most applicable whenever is what we identify as a low risk situation, right? Maybe, if you go to trial and lose, you're still going to get probation versus if they plead, they're going to get probation, right? Or maybe the risk is a little bit, maybe it's a deferred versus actual probation, right? That kind of thing. Like from the cases that you've seen, it's minimal in your mind, right? But huge in theirs. So make sure that you have a perspective of not clarifying this case just because it's a marijuana and not a murder to you. It's that you got to understand where this client is, right? On that. So that's the first step. The second step, I think, is one of the first things I ask my client, one of the last things I ask my client on an initial client meeting is I make sure I understand what are their goals. I will never leave a client meeting without asking what their goals from the onset. I may not ask the what happened question, but I ask them, I say, look, this may be the most obvious question in the world. There are different goals for a case. Some goals may be, I want this dismissed. Some goals may be trial, not guilty, no matter what you learn or what happens. And make sure and explain the goals change. I understand that. But right now, what are your goals? Some goals may be, I just want to plea and get this over with. Some may be like, I will take this much time. What are your goals for this case? And once you have that, when they ask you, what should I do? 2 months, 2 years down the line, well, let's go back to your goals. Because remember, your goal as an attorney is to reach a desired outcome, right? A desired outcome, not to assess innocent versus guilt. I think that helps keep you accountable and puts it back into their place, right? Like, look, well, let's talk about the good facts. Let's talk about the bad facts of everything we've learned, right? And then break it down. And talk about some of the things that you think that you may be able to get that you can't guarantee that these are things that I think could be excludable, right? These are evidence blocking things we can do. And these are our facts beyond change. These are the things that I believe that we're going to have to deal with should we go to trial. And then I start to talk about, remember our desired outcome. Remember when we first met? Remember when we talked about this? We talked about your mom and we talked about your dog and your dog Toto, and we talked about that. And one of the things I asked was, what was your goal for the case? Has that changed? Has that, knowing what we talked about, the good and the bad, the facts beyond change and all that, has your goals changed? And then from that, right, then go from there, remind them of their goals. If your goal is still this, has that changed? Right? And talk about them in risk, because this is one thing I don't like about my job. I graduated finance and undergrad, and in many ways, as a financial analyst, you have to assess the risk of a financial decision. And in many ways, as a public defender, my job is exactly the same. It's funny, like in law school, people are like, oh, finance, why not poli-sci? Why not this? Why not that? Why not criminal justice? Finance? I'm like, well, as a public defender now, years later, there's an aspect of my job that's not much different. I'm assessing risk, right? And so when your client, asking them the same questions, like knowing what we know about the case, do you think we're closer or further away from the goal that you wanted to get? Right? Do you think we're closer or further away? And just remind them that you're going to be in their corner no matter what. Like, look, if you decide trial, then no. Then I'm gonna go all the way. I'm gonna go all the way with you. And if you decide to plea, I understand that too. And sometimes I'm honest with them, because I'll say, look, the man in me, the human being in me, definitely wants you to take this to trial. The lawyer in me, knowing what your desired outcome, seems to point towards a resolution. You said you wanted probation, and the lawyer in me says, remember our goals, no matter how I feel about it. That's the lawyer in me, but the man in me doesn't want you to do it. I'm just being honest, but that I can't let the lawyer, my ego, and I tell them the truth, I tell my vulnerabilities. My ego feels like, and then a lot of them, they'll follow with, you think you could beat this case, right? I'm sure you gotten that too. And I'm so honest with them. And I will say, look, my ego feels like I can beat anybody any given day. no matter what the facts are. But my ego can also get me in trouble. I don't want to put your life on my ego, because there are a lot of things that are outside of my control. No matter how good I am, no matter how dynamic I think I am, no matter how well trained I am, there are things that can go the wrong way, right? And then we start talking about things that can go the wrong way, like judges not going with some of the things that I'm arguing, or jury getting the jury that we just did not want. I start to explain some of those risks, and then I'll ask them, can you live with those risks? If you can live with those risks, I can live with those risks. Or I'll make myself live with those risks by the end of the day, right? I'm going to make myself live by those risks. So opening up your vulnerability, giving them all the information, good and bad facts to summarize, showing identity, just being open about your vulnerabilities, being honest if you're conflicted as a man versus, as a human being. I keep saying as a man because I'm a man, but being conflicted as a human being versus a lawyer, right? Within your role as a lawyer, be honest with it. And I think a lot of times that's going to cause a lot more reflection. And it also challenges, it puts the ball right back into the client's court by empowering them, right? To show them that I'm with you no matter what. So I'm empowering you, then I'm gonna roll with you. So I find that I'm a lot more successful in getting an answer after they said, it's up to you, right? Mm-hmm. After I do all of that, I usually always get an answer one way or the other.
Do you have clients say, I trust you? Like, do they actually say that? Or like, all right, I trust you, you.
It scares me because I've had them say it too quickly.
Me too. Me too. I'm like, wait,
because I had to say it too quickly. Talk about. Yeah, like part of it is like I've worked to break down these stereotypes, and now all of a sudden I have none. And you don't know what to do with it, right? It's like a dog chasing cars. You catch one, you don't know what to do with it. And so it's kind of like, I've had that happen.
Yeah.
I've had that happen. And I still will repeat the same conversation. Like, look, I appreciate your trust. And that means those words are just as good as the words not guilty to me or dismissed to me. However, I still want to hold myself accountable. I want to verify that I've earned that trust, right? I want to confirm that I've earned that trust. And in order to do that, I want to discuss these options with you. I want to discuss these perspectives with you in your case. Is that okay? And that kind of thing.
Okay. I wanted to ask you something else. It's kind of on a different topic, but you talked about earlier some things that are in your client's history that you might not know about at first, like prior sexual or physical abuse, mental health issues. How would you try? We know we can, talk to family members to the extent we have the authorization to do so. But how do we go about having a conversation with the client that there might be potential mental health issues, or, without saying, do you have any diagnosis? What is the best way to get to that information with the client?
I love that you said what you said about assuming we have the authorization to do so. Because a lot of times we're getting contact information. I think it's I'm answering the question, but I think it's an important point, especially for our younger attorneys, that, you don't want to develop the bad habit of getting all these bond contacts and getting this contact information without asking the extra question. Do we have permission to disclose the information, right? Anything that you think that can affect our case, or do I have permission to talk to them about it? Yes or no. Don't assume that just because it's they're the mother of their child or the father of their child, or don't assume that you have it. Ask them. Right. And then it also reassures that I work for you. I'm your boss. I always tell them, like, think of me as your guard dog. Right. You have the chain. And you can tell me, sick whoever you want me to sick. Right. I usually like to think of that imagery. But I say that to say this. I think it's good for attorneys to reach out to social workers, whether you have access to them or not, to talk about signs. Educate yourself on verbal and nonverbal associations with common things that show up, right? Especially within jail. That way you have an idea when you're going into that initial client meeting that it's not, I find that you notice more by observation rather than asking. Mm-hmm. Whenever I have my notepad, I always have a note. I have it with us right now, right? And I'm making observations, right? Rocking, or maybe they blink their eye, and it could be innocent. It may not be indicative of mental health. I'm writing down these things. It's important that you write them down within the first initial client meeting, because what if it's bigger than that And what if it's something that may lead to insanity, which is really as close in time to the crime as possible, right? To the alleged crime as possible, right? And so you want to notate all of these things so then you know what appropriate steps, because let's say you do go, if you equip yourself to know what to look for in a general area, but if you go and you don't have these memorialized notes and you go have a conversation with a social worker, I think they may be mentally or whatever the case may be, they may have a mental impairment, you have nothing to verify. You have nothing at all. It's just going by your own personal assessment, which means nothing. I've met so many when I've supervised, when I supervise attorneys, I think he's incompetent. And difficult is not incompetent. Screaming at you is not incompetent. It means that they're pissed off from the information that you gave them. If someone knows they're facing 20 to life, if they go to trial, if they lose a trial versus a 10-year plea deal, I would be pissed off too. I may not be mad at you, I'm just mad at the situation. Oh, he's incompetent, he doesn't want to hear me. Well, have you ever had an argument with somebody that you really care about? Not saying the client really cares about, but you ever had an argument where I don't want to hear it, no, you start acting like a child. Does your spouse call you incompetent? Does your mom and them call you? Maybe they're doing this as an insult, but do they really believe you're incompetent and then set up a mental evaluation for you? No. So you want to be very observant towards conduct that is indicative. And the only way you can know that is to actually consult with the professional at some point. And there are trainings for this, or attend trainings with social workers doing it. Right now, take advantage of Zoom and all these things to understand things to look for. So that way you'll know if it may rise, and also know the Bennett criteria, right? And not just whether they have the ability to assist counsel. Know the Bennett criteria and know the different things that may go towards that as far as competency. And maybe it's not a competent area, but maybe it's something that you may need help with resources, right? With someone from a client services division. So that way you can know observations. Now, the question itself of asking that, I feel like the observations are stronger than the question, but I will ask. And a lot of times I will go ahead and and if it's sensitive, I may say, look, ma'am or sir, I have to ask something that may seem offensive, okay? But have you ever been diagnosed with anything physically that you know of? Have you ever been diagnosed mentally with anything that you know of? Are you currently taking medications? If you know, and honestly, I feel weird asking it because I probably wouldn't know how to spell it if you said it. But what are the medications? And they may laugh or whatever, and and ask him those things. So qualify it, right? Throw yourself under the bus and be like, look, I just want to know. I'm not saying that I suspect that you are or anything. In fact, this is one of the things I ask everybody, And so if you want to ask, but more so than asking, always observe. Mm-hmm. Always observe.
Now, in addition to observing, let's assume a hypothetical client does not have any documented, any mental health issues documented, no prior diagnosis, no current medications, but behaviors and conversations between the client and some other people indicate to you, based on your experience, that there might be something underlying that nobody has diagnosed yet. Now, we are not mental health professionals. How would we broach a topic like that with somebody that has truly not been diagnosed and is not on medications, without being insulting, just the same way you just said?
I think using those observations, if you've observed them and you want to ask the client about it, I think that asking them, remember when we had that slide and we talked about natural conversation? Mm-hmm. Hey, I saw you were talking with such and such, and I saw you were kind of engaged. Were you mad or were you angry? Right? That kind of thing, right? You're asking questions that go towards establishing the particular question as that goes to that diagnosis, right? Hopefully, like you said, you're able to identify it from your study of it or from your exposure to the concept, right? Your exposure to the concept through some type of training and asking them general questions about it, and if they question you as to why, I think you be honest and just, look, I'm just asking these questions because I just want to have a good idea of you. I want to have a good idea because I'm defending you, and that means everything around you, right? And I just want to have a good idea of who you are, why you interact the way you interact, or why I interact. I mean, look, and be like, if you want to ask me the same question, I'll be happy to ask you that, right? Or those kinds of things. But I don't think you ever lie to your client. If they get to the point and they just challenge you on what you're saying, it's like, they're like, look, I do have, it's very difficult to say, and I don't want to offend you. There are certain guidelines that I have to go by, and I just also sometimes I want to ask questions just to make sure that you're not going down that road, right? And explaining them what it is, right? If it's competency, like, there's something that you may hear the word competent. And the tricky thing about competency is that, yes, I can tell the judge whether I think you're competent or not. But if a judge saw you doing what you're doing, they can override me and make a determination as to why you're competent. And if you, and should you be competent, I definitely don't want the judge getting the wrong idea that you're not. So I'm asking you these questions to make sure that the judge doesn't get the wrong idea off of something that's real natural for you. So, and he's like, I'm competent. And like, look, okay, I'm not saying that I disbelieve you. What I'm saying is I want you to empower me with information so I can make sure that they know that, right? To make sure that they know that. So if I ask you some of these questions, they're going to get pretty specific. They're going to get pretty, they may get pretty personal. But I just want to know, in order to, if it ever comes up, that I'm able to let the judge know not to make any assumptions about your behavior, right? Not to make any assumptions about anything. We hate when people assume things about us. And I just want to make sure that they don't do that about you, right? That kind of thing.
Okay.
Because, clients are protective. They may ask, why are you getting into all of that? Like, if you start going into it. So those were meant to be two different approaches. You can just kind of organically go into asking these questions, right? Or you can just go to the butt of the matter and say, look, this is, competence. And have you ever, what that is? And explain to them that, the thing is that, it's not just you that can call it. Now, the prosecutor may not be able to call it, but you or the judge can, right? And the judge can override you, right? They can, at least I know in the states that I've been exposed to, they can raise competency. Mm-hmm. And so if anything else, you want to be concerned to keep them from that, and you have to be able to defend why they're not, why they are competent, just as well as you maybe have to present why they are. Keep that in mind too. A lot of times we're always so focused on proving they're competent, but you may be in a position where you have to prove they're not.
Right. Yeah, that's a good point. Gosh, I took so many notes. You mentioned staying in contact with clients to keep them informed, and obviously we all know why that's important. You don't need to, I'm sure you don't need to explain that to any of the attorneys watching. But if you say something like, I will call you when, like, I will call you when I get discovery, or I will call you when I get the body camera footage. What if you just don't have it? What if it's taking a long time? Like, for example, during COVID, sometimes I get discovery right away, and sometimes I don't. And I understand everybody is bogged down and the courts are backlogged, but it happens. So how do you call your client if you have nothing, if there are no updates? What do you suggest?
If I gave them my word that I will call them, I'm going to call them even if I have nothing. But if it's a standard situation where it's kind of organic, whether they contact you or not, a lot of times I just like to let my client know things from the get-go. Maybe one of the things during that initial meeting, it's just like, look, Mr. Kim, I saw Mr. Kim on here. So, Mr. Kim, one of the things I'm going to be focused on between now and the next time that I see you, whether it be on Zoom or whether it hopefully be in person, I'm going to be trying to collect as much information I can, because I'm assuming the question you want to know is how strong your case is, right? Do you have a shot, or can you beat it, or whatever the case may be? That would be the question I would want to know. I can't make that determination until I know everything that they have. But here's the problem. The problem is that I don't know, because it's their job to get it to me. I can't control how fast they give it to me. So I'm going to ask for your trust, and I'm going to ask for your patience. If, when it comes to discovery, if and when I get it, I will inform you and let you know. I have to be honest, if you haven't heard from me, it may mean that I just haven't gotten it yet. It probably means that I just haven't gotten it yet. But when I do, I will contact you. I will make an attempt to contact you, right? And so you let them know that up front, that these timetables take a while and COVID is going to influence that. In the meantime, I'm going to be looking at what I do have and trying to speak with an investigator, right? And trying to think of things that you do in your normal day that just become organic, but you are still doing them, right? In the meantime, I'm going to look at filing a discovery notice for you. In the meantime, I'm going to be trying to identify what people that I think may be important to the government's case. In the meantime, I'm going to be, for example, I think stray away from timetables, especially if you don't know them. They may say, well, how long is that going to take? And be like, remember, the one thing that you can always count on me is to be trustworthy. And I can't tell you how long it's going to take. But my goal is by the end of the week or by the end of next week to talk to an investigator about this. Or my goal is, I like to tell them what my goals are. My goals are, to give them some type of, I can't tell you when, I don't know when. My goals are to try to do this. My goals are, I don't know when a bond hearing is going to happen, but I will like to try to contact the coordinator to the court or the minute clerk or whoever it is that does your scheduling. I would, my goal is to contact the court within the next week to find out when they are setting these hearings. And letting them know, just like, look, sometimes they're just, right now with COVID, they're just setting these hearings without even contacting me, right? So my goal is to try to, converse with them to see when they're setting them so I can inform them, right? Let them know the honest truth of what's going on. Because I think a lot of times attorneys, they don't just wake up deciding to give these vague answers. They give these vague answers because that's what they rely on, vague information from the court, right? And you're trying your best to navigate around this vagueness. I think being upfront and honest will cure a lot of it.
Okay.
Especially during COVID, nobody really knows anything.
I know. I went to court this morning for a client and had no idea that cases that were in that client's particular category were not even being heard. There was a big poster, like it looked like a poster from elementary school with marker written on it. Such and such cases continued to further notice. Like, that's nice. Thank you. Nobody's.
I like to tell clients too.
Office. I told the client, I just, unfortunately, I just don't know, but I'll let you know as soon as I know something. And believe me, I want to know when I have to go to court too. So I'm going to get on top of this.
We have the answers to these questions. It's just sometimes when we're put on the spot, we can't answer them because we have 50 million things going on in our head. But if we stop and think about some of the things we're doing, we do have the answers to provide to our clients. Kind of like, look, I'm meeting with my colleagues every 2 days, is trying to figure out how can we push the court to be more clear as to what we're doing. You're probably doing it. Maybe it's not about their specific case, but you're doing that, right? I'm trying, I could tell you right now, I'm going to meet with my colleagues in the next 2 or 3 days and try to figure out exactly how they can get to, how do we make them accountable to being, more in touch with us so we can set days quicker, so we can give you the things that you're asking for. Unfortunately, I have to look you in the eye, sir, and tell you I don't know. But I am working on getting the answer to no. And I can tell you that I'm talking with my colleagues in my offices and we're trying to figure out how to create an efficient system to do that. In fact, I have a meeting with such and such in 2 days about it. And your case is going to be one of several that I'm trying to, that's going to be in a discussion, right, about that, something like that. It's like, it just doesn't come to you, but you have to really, stop, think. Don't be so quick to give an answer. Stop and digest what they're asking. Right. And it's kind of like listening to direct. We want to get our cross out, right? We just want to get our cross-examination out. We're not listening to what's being heard. And we all fall into it. Listen to what the client is asking you and stop and think about how much of it is embedded in your day as it is. And what clients really are looking for is hope. They're not necessarily looking, in my belief. Yeah, some have unrealistic expectations. Some of them do have goals that they want to achieve. But I think the thing that they're looking for the most is hope. Whether it's hope that you're a fighter or hope that you won't give up on them, which may not be the same thing. They're just looking for hope, right? It's hope that they're not forgotten about. And a lot of times I lead with that, before every interaction, whether it's been 2 months or whether it's been 2 days. Look, I want to let you know I haven't forgot about you. I know that you're calling, but I have not forgotten about you. This is what's happened. The court is still meeting, and they set trial dates back into November. And I want to let you know that. I know you haven't made a decision where you want to go with your case, but give them an update about anything, right? There's always an update about something. Like, look, none of the updates about your case specifically, but I can tell you about what's going on in the courthouse, and I think this may have an impact on your case, or this is how we may be able to use it. Maybe the fact is, look, it's been 2 months and they still haven't given me a report. I usually like to stray away from filing speedy trials, but I think this could be a potential route to go, to force them to do that, to speed up, or whatever the case may be, or file a motion to compel. Also start looking at your things, right? Look at what you have at your disposal. Motions to compel and pushing a fire into the state to do that. Motions of inventory and supplemental discovery. Start litigating the fact that you don't have discovery, or start setting a paper trail, right? A lot of times I'll file my discovery notices. They'll give me what they give me. And then I'll file a particularized supplemental motion with an inventory. I'll inventory what I have, and then I'll write a supplemental about the things that I think could exist based on what I know to exist. For example, maybe in a report they refer to body camera. I'll make sure and factually cite at the bottom of my motion that they believe to be body camera. And the reason why I do that, I don't remind the state to give it to me. No, I don't do that. I want to have it in writing, and I file it, and I ask them to reply in writing. It does two things, and it does help your investigation, especially on these cases where you don't know where they're going to end, right? And this confusion. It still holds the state accountable. One, they're replying that they don't have it, which means that you can take that and incorporate that in your defense theory. That's a fact you don't have to deal with because they don't have it. If it's something that's good and they should have it, that could set you up for a favorable or missing evidence instruction for a jury instruction later on down the line. And if they don't have it and it's bad, then that can set it up for an exclusion as a discovery violation and ask the judge to give them a sanction for delayed discovery, right? So you're setting these blocks up and you're letting your client know this strategy as you're doing it. Be like, look, I know that you've heard me call you 3 times to tell you nothing has happened, but this is what I filed. Remind them of the motion you filed. Like, look, I filed this supplemental motion. And, remember what we talked about. I told you we had this and that, and we're still waiting on these things. I know to you, waiting 2 or 3 more months in jail is horrible, but down the line, this is what I think we can benefit. And this is one thing I'm going to continue to incorporate in this motion and raise it, right? You want to let them know what the long-term plan is, but make sure you have a long-term plan. Don't just speculate one.
Yeah. Yeah, that's really good information. I'm still taking a lot of notes. So if you see me looking down, that's what I'm doing.
Oh, sure. I think we can use litigation. I think litigation and building client trust works hand in hand, especially for these cases where you feel like you can't get your client out of jail, they're sitting in jail, the bond's too high. If nothing else fails, I'm going to bring up bond again, even if you feel like you're going to lose. Nothing beats a failure but a try. Look, I'm still waiting on discovery. I'm still litigating. I've updated our motions. And I tell you what, I know this is unfair to you, and I know that it's horrible. Even if it's a murder case, I'm going to readdress bond. I'm going to readdress bond, and then, try that. Or I ask them, is there anything that I can do? Is there anything that you think I can do? Right?
So I wanted to ask another question about trust. You mentioned a lawyer, well, I think it was in your hypothetical, talking about golf or something with the prosecutor, or just chit-chatting. I almost used an expression that I shouldn't use. I'm sure there's a fine line here. How, because on one hand, it's going to help you. I mean, I would say, I shouldn't even say common sense. It's probably like the make sense phrase. But to me, it seems like if you have a good working relationship with the parties on the other side, police officers or prosecutors, that it's just going to make the whole process easier. I mean, I really do think that's true. Let me know if you disagree. But how do you how do you deal with that in court? How do you deal with being nice, polite, whatever word you want to say, with the other side without your client thinking that you are working with the state? And how do you convey to your client that you're doing what you're doing for a reason, whatever your tactic is. Maybe you always come across as an aggressive person, or maybe you don't want to come across as aggressive because that's not the way you are going to get what you are trying to get. Does that make sense?
Oh, I understand it. It's a dilemma.
I can't believe I said, does that make sense?
No, I get it. It's a tick. I get it. You know, that's why whenever you said it, that doesn't make sense. I already identified it as a tick because in a lot of the trial schools, whether it's Harvard or whether it's Gideon's Promise, a lot of time the practitioner will have a tick, and we identify that tick, right? It just happens naturally. I don't think you actually mean it. It just happens. But to your question, the smaller the jurisdiction, the smaller the county, usually you encounter this more, right? And I don't see it as much in Houston because that's the third largest city, and I'm in Harris County. It's the third largest county. That's the third largest county in the nation. So it doesn't happen as often for me being new. But in Louisiana, we have 64 parishes. That's in this state. In the state is very, very small. And there are places, even in your bigger cities like New Orleans, where it's still very relationally built, right? Everything functions around relationships. So I understand it. What you have to do is, I think a lot of it, you kind of answered your question. You communicated to your client by letting them know your strategy and letting them know, like, look, you're going to see me walking here. And I'll be honest with you, I went to school with this guy. And because I went to school with this guy, I know what their strategies are. And I think it could be, and so when you see me say hello to them, I'm acknowledging them. But it doesn't mean just because I know this person that I'm friends with them or that I have some type of allegiance to them. My allegiance is to you. You let them know that. And I think you also let the prosecutor or the judge know, look, if they're really as close as what you think they are, then they should understand. Saying, look, judge, or hey, may I approach? Judge, I don't want to be rude. It's just that my client is very observant towards the interaction. And I just don't want to give my client any type of wrong ideas that just because we have extended conversations, the extended conversation seems to bother my client. Or say, they seem to bother my client. And I don't want them to bother my client because it's going to disrupt our efficiency. It's going to disrupt my ability to represent them effectively or their belief in my ability to represent them effectively. And I think it can overall result in an inefficient process, right? Judges, when they hear inefficient, they get scared. They get nervous. They hear the word inefficient, right? Prosecutors, same thing with them. They want to move a case. And that's what those two are aligned to do, move cases. And when they hear the word inefficient, they don't think of moving cases. Your goal is not about moving cases, but it's something that hurts all of you if they continue to see this, right? So that's one way. Now, how you should behave, I'm not saying you walk in there, fire and brimstone, hey, you know what, screw you, you're this, you're that, I'm not saying that. I certainly don't think you do that. I think there's nothing wrong with hello, how are you? Hope you're well. But these extended conversations as, did the Saints win? What was the score? Hey, did you see that play? Did you see all of that? And then your client's just sitting there in the audience. But the moment your client even picks up a cell phone, a deputy is demanding that they get out of court. But here you are talking about, the baby shower that you went to and all this other case, right? If a client even wears a hat in court, he's being shouted at. He or she is being shouted at, but yet you're having this conversation that gives the image that you're concerned about everything but them. So you have to, I think if this person, whoever this party is, truly respects you and they have this friendship with you, they should respect, they should understand when you say that and not get offended, right? Because you work for your client at the end of the day. And I know that sounds harsh, but you don't work for the judge, you don't work for the prosecutor, and you work for your client at the end of the day. And you have to also be careful that, I see a lot of people, they take the deference to the court to the extent of really, really demonizing their client. You're up there at the podium with your client, and the client is trying to ask you something like, shh, the judge is talking. The judge, don't do that, right? Or don't validate or invalidate what the judge is doing, right? Oh, you better thank the judge. You better thank the judge, right? Or if the client disagrees with a plea agreement, I see a lot of this too. If the client doesn't want to take a plea offer and you're approaching with the state and the client is in the audience. I don't know, Judge. I mean, it's a great deal. It's a great deal that the prosecutor offered. I'm not sure why they won't want to take. All these things break down client barriers. And I mean, fundamentally, I really have an issue with that, with attorneys. I really do. I see it a lot. And I hate that. I really absolutely hate that. And I know that might be getting a little bit unprofessional of me, but it's just really holding our behaviors accountable, because when we do that, we're adding to the system that we all complain about. When we're doing that, we're no better than we want to chant, we want to chant against police and police reform and look, what are we doing to add to that? These things add to that. So some of it is just the hard answer, as in no, right? I'm not saying you can't be friends or date or any of that. I'm not saying that, but there is a line drawn. And whenever you are in the scope of representation, that client has to come first, right? And any party that respects you beyond the profession should understand that. They should understand that, right? And so that's a harsh answer. I know it's kind of direct, but there are some things that I think are kind of, I don't think it sacrifices a working relationship to do that necessarily. You're not asking to be mean and be upsetting, but at the same time, just, hey, let's just tailor the personal extension of, we just feel it would just be better for my relationships, Judge, if we did that, if that's okay with you, right? I would love to I'll continue the conversation in your chambers if you like, or in the hallway, or once the case is closed, or once the case is closed for the day. But I just want to make sure Your Honor understands, and your tone, right? There's a tone of deference and respect. So I think we got to monitor these interactions. And I know I gave a lot of varying examples, but you want to be very, very careful about how we interact about that. It's not just the clients that are watching, it's other families that are watching. And God forbid if you have political aspirations. Right now, everybody is running on these progressive platforms. Mm-hmm. And yet you're on record treating your client like this, and then have the nerve to go run on progressive platform and talk about, how we want to do this and watch how we treat, but this is how you're doing every day, right? There's somebody that's keeping a tab on that. There's somebody, right? You may not see it, but someone sees it, and so you want to be mindful of these interactions, because it can be very, very dangerous, and it can create a dangerous person. I don't think any attorney wakes up wanting to be that way, but over time, habits start to multiply on the habits. I refuse to believe attorney woke up saying, I want to process human beings, whether they're a prosecutor or whether. I refuse to believe that you got in the profession for that. I don't. I think these are created over time, whether it's being overworked, underpaid, all of that, they start to be created. And the only way to defeat that creation is to hold ourselves accountable every day, every time, right? And that means having the hard, difficult conversations that we're having now, right? And that's what we have to do. Our clients deserve that, and their poverty level should not dictate otherwise.
Well, you said a minute ago, sorry about being direct or something like that. I don't think you should apologize at all. I appreciate you being direct. That's why we're talking about this. And I'm asking questions that, I'm asking them because I don't know what your answer is going to be. And I'm not afraid of the answer because, I want to know. I want to do my job. And I'm sure that, everybody who's watching this, can benefit from this, because in everything that you've said over the past 2.5 hours, I could keep going, but I think back on all these things. I think, oh, I hope I never did this, or a time where I did do that. And I'm like, oh gosh, I shouldn't have done that. Or did I do, but it's important to be aware of these things, because at the very least, if we're aware of them, we can try, to
and we're
down on the stereotypes, because you need to be.
It happens.
Yeah.
It happens. It happens to the best of us. I mean, the other day, I felt like I had a frustration with a client, and I apologized. They were asking me a question. I felt like they were getting loud, and I had to stop and say, you know what? I think that maybe I could have handled that differently, right? And I'm like, it happens to all of us. And here I am giving a presentation on it. So the first thing, if any attorneys are watching this, and you're saying, that's me, I've done this, don't beat yourself up, learn from it, That's the beauty of our profession. It's a practice, and every day we can make a new day, right? And we learn from it. We have emotions too. I'm not asking anybody to ignore that. We do have them, but the more we're conscious of it, the less it will happen. right, the less it will happen. You know, because I always say we're a mistake and a layoff from becoming our clients. And most of us are privileged enough not to have experienced both at the same time. You lose your job tomorrow, right? And you do it and you make a mistake. And it doesn't have to be an illegal one. It could just be in the wrong corner at the wrong time. It could be getting in a car with a friend that maybe is into some stuff. And because they constructively possess something, you're arrested too. It could be that may be a mistake to get in with somebody that you know has questionable character, right? But that's not illegal. But hey, maybe you shouldn't have done it, right? That kind of thing. So my point is that you lose your job and then you have a mistake at the same time, you're going to be needing that public defender that you want to be. And you hope that is the person that you see yourself in. So don't be somebody that you wouldn't want to hire or you wouldn't want to have if they were your public defender.
Mm-hmm. Yeah. I could just keep talking all day, Kenneth. Thank you so much. Before
No problem.
I'll ask if you have anything else to say, but I definitely think we should have a conversation again, because I really got a lot out of this, and I'm sure everybody who's going to be watching this recording will too. So we should definitely do something. And I'll actually ask everybody to leave a note in the comments about maybe something in particular you would want us to talk about. You know, we might not be able to get to everything, but please do.
Yep.
Because like I said earlier, there might be other questions that other people have too, and I thought I had a lot. But before we go, is there anything else that you wanted to say to everybody to recap, or just anything additional?
One thing that was probably the biggest blunder that I made, I realized I didn't even leave my email address, and I usually keep them on my PowerPoint presentation, so I apologize. My email address is KENNETH @PDO.HCTX.net. So that's Kenneth.Hardin @PDO.HCTX.net. That will be my email address. And also, I've agreed already to do another presentation with you on August 14th. August 14th at the same time. And that will be titled Storytelling Through Cross-Examination. It will be a little bit more skills-based. I know this presentation was more value-based. This will be a little bit more skills-based. That will explore in depth a little bit more detail, a little bit more of an advanced cross style. You know, as a building block to your basic cross-examination techniques. So I look forward to speaking with you then, Prince William County, and I'm so honored that you think highly enough of me to invite me to talk with you, to speak with you, because we are all evolving in this practice. And don't give up. I know that this is a tough time. I know it feels like Groundhog Day, and sometimes we feel limited. And if we didn't feel limited before, we really feel limited now in the things that we do with our clients. And just remember that you're always the answer to someone's prayer. So just you getting up in the morning and deciding to put on, I guess I was about to say your suit, but maybe your jogging pants, maybe, you know, whatever it is that you put on now these days, you know, just remember that, you know, taking care of yourself mentally, emotionally, that's the prerequisite to being able to take care of a client. If you're not taking care of yourself, you can't take care of a client. So use this time, self-reflect, grow, continue to work up your cases. Remember that you're the answer to someone's prayer, or take it as a blessing rather than as a burden. And I look forward to working with you and meeting you all in person. I'm only an email away, and I wish you all the best. Take care.
Well, thanks, and thank you for leaving us with that positive note. I know I was inspired after your presentation that I heard in May, and I'm inspired now. So thank you.
No, thank you for having me. I really appreciate it.